Not yet? Okay, okay. We have a full schedule today, guys, and I'm afraid the morning may go a little long. So I want to go ahead and get started on that. Welcome again, and Amelia, do you want to kick us off?
Good morning, Madam Chair, members of the committee. My name is Amelia Kovar Donahue, and I'm an assistant revisor in the Office of Revisor of Statutes. And I have provided a brief outline for you this morning if you wish to follow along. But I just have a few brief remarks today. It looks like my outline today goes over some constitutional and statutory requirements relating to valuation for property tax purposes. And where I would like to start this morning is with the Kansas Constitution, Article 11, Section 1. One of the provisions in there is that except as otherwise hereinafter specifically provided, the legislature shall provide for a uniform and equal basis of valuation and rate of taxation of all property subject to taxation. And that's when you hear people refer to uniformity and equality, oftentimes that's what they're talking about, is that provision right there, if they're talking about the constitutional provision. I have a few case law citations there for you. There is obviously substantial amounts of case law interpreting this provision over the course of time. And so I've kind of given you a few citations there. One of the important things to know, which you probably already know, is that the legislature has adopted fair market value as that uniform and equal basis of valuation. So when we think about that constitutional mandate that says the legislature shall provide for a uniform and equal basis of valuation, the legislature has done that by the use of fair market value. This uniform and equal rate provision also has been found to be virtually identical to the protection granted by the Equal Protection Clause. And also, there are cases that talk about constitutionality of a property's valuation, whether the method was constitutional. There are also cases that talk about whether a statute is constitutional. So when you read cases, if you're looking at them, you can kind of see whether they're kind of as applied or the law itself. And one of the cases I have there for you is an older case of Greenhaw. And it was a case, the citation I have here for you is that when determining the validity of an assessment of real property for uniformity and equality, the essential question is whether the standards prescribed in KSA 79503A have been considered and applied by the taxing officials. And that particular statutory citation we're going to get to in a minute, but that's the statute that defines fair market value and provides the factors that need to be considered by the appraiser in determining the fair market value of a property. Also, more recently, there was a case, opinion from 2016 that dealt with a challenge to the constitutionality of a statute. And in that particular case, the court found, expressed again, which can be found in many cases, that the proper test in determining whether a valuation statute conforms with this mandate is to determine whether the special treatment given to the valuation of one group of property bears a reasonable relationship to the actual fair market value of the property. And the point there is that the special treatment be related to the fair market value of the property, not the circumstance or situation of the owner. So the statutes need to be related to the type of property. And when we talk about these cases, one thing also to keep in mind is actually not with the cases, but the constitutional provision, if you read it again, it says except as otherwise specifically provided in the Constitution. There are some types of property that do not fall under this fair market value standard. One of in relation to real property or real estate, all real estate is valued by fair market value, except land devoted to agricultural use. And that's an exception that's found in the Constitution, both in Section 1 and Section 12. Section 12 talks about using income and productivity, and also provides the legislature the authority to define land devoted to agricultural use. And I have there on page 2 of my outline, I've cited some statutory references, 79-1439, that talks about that classification. And then KSA 79-1476 is the statute that actually sets forth that valuation methodology for land devoted to agricultural use or use value. And then there's a more recent statute, 79-1476C, which codified, I believe it was a memorandum from the Division of Property Valuation related to adverse influences and how that affects use value. So you can take a look at those. My presentation today doesn't really go into land devoted to agricultural use. We're really here to talk about fair market value. And so I just want you to be aware that when we talk about all property and fair market value, it's really, we're not talking about the exception of land devoted to agricultural use. There's also a couple types of personal property that is not valued on a fair market value standard. There's other standards provided for those types of personal property. One is commercial and industrial machinery and equipment. The Constitution provides a valuation methodology for that type of property. In a general sense, it's the retail cost when new of the property less depreciation, and then there's a, it can't go lower than 20%. But that's provided for in the Constitution and then also statutorily in 79-1439. There's some other types of personal property that also are not fair market value, tag and tax motor vehicles, recreational vehicles, some things like that. But the other categories, if they're not accepted, the other categories of personal property are also a fair market value standard. They may have some other methodologies that are more specific to those types of property, like oil and gas leases. PVD has a guide for oil and gas leases and things like that, but those are still a fair market value standard. So the statutes governing property valuation or property taxation generally can be found in our statutes in Chapter 79. The general concept when we talk about fair market value is that for property tax purposes, all taxable real and tangible personal property shall be appraised at its fair market value as of January 1 each year, unless specified by law. And when we see that otherwise specified by law language in many of the statutes, it's really a reference to those exceptions like ag land and personal property that has some other standard. Some examples I have listed for you. These are just a smattering of examples to think about that appear to be an effort by the legislature to provide for this uniform and equal basis evaluation. And there's more than this. These were just things that I thought might interest you if you're interested in doing a little more looking. KSA 79-1439 in part provides that all real and tangible personal property which is subject to ad valorem taxation shall be appraised uniformly and equally as to class, and unless otherwise specified herein shall be appraised at its fair market value as defined in KSA 79-503A. Then when we look at 79-503A, there you will find the definition of fair market value. It means the amount in terms of money that a well-informed buyer is justified in paying and a well-informed seller is justified in accepting for property in an open and competitive market, assuming the parties are acting without undue compulsion. That particular statute also provides a list of factors to consider, like sales, That list that is provided there kind of essentially sets forth the three approaches to value that you might be familiar with. If you've seen appraisals before, you might have come across the sales comparison approach, the cost approach, and the income approach or income capitalization approach. So those factors kind of follow those approaches. Our statutory scheme also provides that county appraisers and district appraisers must annually appraise property as of January 1 each year. That is actually restated in several statutory provisions. You can find it, I have a few of them listed there for you. The county or district appraiser shall actually view and inspect every parcel of real property in the county once every 6 years. Again, trying to make sure that there's uniformity and equality in the process. The Director of Property Valuation shall also annually determine the fair market value of public utility property. So county appraisers are not the official who values public utility property. That is the Director of Property Valuation, but again, fair market value as of January 1. There's also, again, trying to find uniformity. The Director of Property Evaluation has the general duty to devise and prescribe uniform assessment forms and tools and render assistance to the county appraisers provide assistance toward uniform assessments within counties and throughout the state. Also, the Director of Property Evaluation must perform and publish an annual sales ratio study, which is comparing sales that occurred within the county compared to their appraised value as kind of a test or check on those appraisals. Director of Property Valuation also determines whether counties are in substantial compliance with the law and to appraise taxable property. They publish those results on an annual basis. And there's also a complaint process to request reappraisal of all or part of property within a county under certain conditions. That is found in KSA 791413A. And there's also a process for compliance plans. If a county is not in substantial compliance with provisions of law or guidelines of the director, there is a process for instituting a plan so that they can get into compliance. And that is in KSA 791479. So looking at appraisal specifically, our statutes, again, I'm going to refer back to 79503A, which is our definition of fair market value, the factors to be considered. It also provides that the appraisal process utilized for this valuation shall conform to generally accepted appraisal procedures and standards that are consistent with the definition of fair market value. And those generally accepted appraisal procedures and standards can be found in USPAP, or the Uniform Standards of Professional Appraisal Practice. And you will see we have another statute, KSA 79505, that specifically provides that the Director of Property Valuation shall adopt appraiser directives, prescribing appropriate standards for performance of appraisals. And that those appraiser directives shall require at a minimum that all appraisals be performed in compliance with USPAP, and that those be written appraisals. We also have a statute that provides that the county appraiser shall follow the policies, procedures, guidelines, and valuation methodologies of the Director of Property Valuation. That's 791456. I know sometimes there are some questions about appraisal. I want to note here on the last page, mass appraisal. Sometimes you hear the term mass appraisal. The term mass appraisal can be found in USPAP, the Uniform Standards of Professional Appraisal Practice, and it defines mass appraisal as the process of valuing a universe of properties as of a given date, using standard methodology, employing common data, and allowing statistical testing. The Director of Property Valuation, pursuant to his authority under 79505A, has adopted a directive, and it is Directive 24-51 that addresses USPAP and the use of mass appraisal and single property appraisal, if you're interested in taking a look at that. And then the other thing related to mass appraisal, I don't want to go my presentation is not actually the appraisal process. I think you might have another comfrey today on that. But I do want to note for you that in our statutes, there is a designation called registered mass appraiser, and that is specific to Kansas. And the our statute 19-430 talks about our county appraisers. And one of the requirements is that no person be appointed as county appraiser unless they hold a certified general real property appraiser designation or license from the Kansas Real Estate Appraisal Board, or they hold a registered mass appraiser designation. And the registered mass appraiser designation is a designation provided through rules and regulations that are adopted by the Secretary of Revenue that is specific to Kansas. And I have a citation down there for you if you're interested in looking at those rules and regulations. They start at KAR 93-6-1. And I would be happy to stand for questions.
Thank you, Amelia. That was excellent. Committee, I'm sure there's questions. If not, I have a few.
Okay.
Well, one of them, we talk about, well, I've got so many, I don't even know where to start. So we talk about the Constitution versus statute, and we keep hearing the term fair market value, but then it gets a little bit complex because there's 3 ways to arrive at the fair market value. Is that correct?
Correct. There are 3 approaches to value that may be applicable.
The cost, replacement, income, is that
Sales comparison approach,
sales comparison? Okay,
cost approach,
okay,
or income approach. Those are the 3 approaches.
okay. And I've heard replacement.
Replacement cost is part of the cost approach.
Okay, okay, good. So I would ask also, and I've asked this before, I'm not sure, but is it uniform and equal across the state or across the county? Or where is there's no clarification for that, is there?
It would,
And if you need
it would
to.
seem, no, it would seem that from the Constitution, I mean, the uniformity of the law needs to apply across the state.
That's what I thought.
And so the uniform and equal basis evaluation that the legislature has adopted is fair market value. And so is the property being valued at fair market value across the state? Now, it also may be within the county, if that's the issue, but it's also throughout the state because the standard is fair market value.
But if we have an appraiser that's using values from Colorado, that shouldn't be occurring, is that correct?
Well, I don't want to go into the actual appraisal methodology.
Okay, okay, I'll save that for.
But, the statute, the manner, the standard is fair market value. Okay. So that's the question.
Okay, okay. What happens is there a penalty if the county appraiser does not follow? And we don't have to have a county appraiser. That's kind of a misconception. We also can have district appraisers. Is that correct? Or it may be different terminology.
Madam Chair, the statute does also provide for district appraisers. So I don't believe, and PVD can correct me if I'm wrong, I don't believe we have truly district appraisers appointed at this time, but there is a statutory provision for that to happen if the statutes are followed, to have a district appraiser versus a county appraiser. But when we look at the duties of the county appraiser, if certain counties were to have a district appraiser, those same duties apply to a district appraiser as well as a county appraiser. They're used kind of interchangeably when we're talking about the duties.
Okay, and what if there is a county out of compliance with what PVD has directed? It says that they have to follow it, but there's no penalty, is that correct?
And maybe this might be more of a question for PVD and how they administer that. There's provisions for if there's an issue, there are a couple things that I pointed out there. Request for reappraisals if it appears that there's not, if something was amiss. And then substantial compliance, compliance plans to get counties back into compliance. So.
Yeah, and what I'm trying to get at is, I hear from my county commissioners, we have no authority over our county appraiser. And then the county appraiser says, no, we answer to PVD, and PVD says, no, we have no authority over the appraiser. So we've got kind of a circular thing going on, and I'm just trying to figure out where we're at in statute now. And we can look at this later. I just want the committee to be aware of I'm sure you guys are hearing the same things too.
Well, and that was one of my little notes here is, as you just pointed out, county appraisers or district appraisers are appointed by the Board of County Commissioners. And there are some statutory provisions governing how that's done and what authority the Board of County Commissioners may have. So and there's a citation there on page 2 if someone wants to take a look at that appointment process.
No, that's perfect. Any other questions, committee? Representative Smith.
Thank you, Madam Chair. Thank you, Amelia. Just a few comments, and I know when I was a county commissioner in Wallace County, we created, because we're a small rural county, we didn't really feel we needed a full-time appraiser, and we created I think we created the district that you were talking about with another county, kind of a joint appraisal district. There was a specific name for it. I can't remember what that was, but we went together with another county, just number one, for a lack of certified appraisers out in western Kansas. So we did have one appraiser that was willing to do 2 counties. I'm not sure if that's something that's, we've got that process in statute right now, but it may be perhaps there's something that we can do to improve that and make it easier for, I know there's multiple appraisers out there right now that serve multiple counties, especially out in western Kansas, because number one, the small counties, like I said, don't have enough work to justify a full-time appraiser themselves. But there's also a lack of the appraisers. I don't know if there's anything different we can do to look at to make that process maybe simpler. It was a process. Wallace County went together with Sherman County. It was a process trying to get that done. We did get it done for, I believe, a couple of appraisal cycles, and then we went back to having our own. But another question I had when you were going through your presentation, do we have any statutes? Again, I'm from a small rural county. We have one grocery store. We've got a couple of gas stations. We've got a couple of restaurants. How are appraisers, and maybe this is a better question for Mr. Kent, but do we have any statutes that direct appraisers on how they're supposed to value properties that essentially have no comparable sales when it comes to that? I know there's the different methodologies, but when you don't have a good sample, can they go out of county? Can they go out of state to find, we're 3 miles, Weston is 3 miles from the Colorado border. We probably have different statutes governing appraisals than Colorado does, but if a grocery store sells over in Colorado, maybe it's 10 or 15 miles away, it's probably pretty comparable to what a similar store would, sell for in Kansas. But I didn't know, do we have any statutes on the books, or maybe their directives or regulations?
Madam Chair, I am not aware of a statute that goes into that specific of detail, but I believe there may be directives of the Director of Property Valuation or guidelines or instructions relating to that. And so I would probably defer to Mr. Kent or other conferees regarding what instructions may have been provided to county appraisers in those particular situations.
Okay. Yeah, and I might ask that question again when Mr. Kent gets up, because I just want to make sure we've got some reasonable parameters in there. I would hope that most appraisers would try to find something comparable, but just want to make sure that Wallace County isn't going to Wichita or Sedgwick County to find that information and compare those, and think that that's going to apply the same as Wallace County. So.
Question. Any other questions, committee? Representative Long.
Thank you, Madam Chair. Thank you, Amelia. My question has to do with appraising oil and gas. So I'm from a district with 4 counties that are heavily loaded with oil and gas. And so my question concerns appraisers that, do they have to meet additional standards to be able to appraise oil and gas? The reason I ask is because we didn't have that, and so we contracted appraisers specializing in oil and gas each year. We don't do that anymore, but as county commissioner, I used to do that a lot. And so I was under the understanding that to appraise oil and gas, they had to have special certification. Is that right or wrong?
Madam Chair, I honestly don't know if they need a special certification. I believe there are competency requirements to do appraisals generally in USPAP, as well as possibly the directives of property valuation, and possibly property valuation may be able to provide some better explanation of what they require regarding oil and gas valuations. They do have a guide, but there may be some competency requirements that they have, or they may be a better comfort to ask.
Yeah, there's just not anything in statute would be, or it gives the directive for PVD to, I don't want to put you on the spot because to know this stuff off the top of your
Yeah,
head.
the difficulty is, our statute is referring to generally accepted appraisal practice. It doesn't get down to the, the minutia of, necessarily this particular type of property or this particular set of circumstances of this particular property. We do have statutes that govern oil and gas valuation, though. So there are some additional factors, not only 79503A, but also 79, it's in the 300s. I can't exactly come up with the number, but there are some additional statutes that govern oil and gas properties to achieve fair market value.
And we'll be going over some of that this afternoon. Yeah. So Representative Francis.
Thank you, Madam Chair. And it may be something that PVD has to answer, but is there in statute a definition of what business and machinery equipment is? As you know, there's a lot of litigation on that on some industrial plants as far as what's real estate, what's business and machinery equipment.
Madam Chair, there are some statutes that touch on that topic. I just off the top of my head can't think of them. I can look them up when we have a moment, and if the chair would like me to come back a little later with some of those statutory citations, I can give those to you or to the committee.
That would be great. Thank you, Amelia. Did you have another? Okay. Senator Peck.
Thank you, Madam Chairman. Switching gears entirely here. You said, if I heard right, that there's a requirement as it relates to licensing and education for appraisers. So if the legislature were to make the county appraiser or district appraiser an elected position, that we would need to change statute because some people that run for the position may not be licensed or trained, but that could be overcome potentially by legislative change of the law to where someone in the office under the direct supervision of the elected county appraiser was licensed or trained. And I know I'm asking a big question, but there has been, just a little background, there's been off and on discussion about we should have, as some other states do, a person who appraises the property who is accountable to taxpayers. But currently, we would either need to change the statute or it would be nearly impossible to find that many people willing to run for office who are licensed and educated in appraisal. So again, back to the question, if we were to make that statutory change, we would also need to change the qualifications or potentially need to change the qualifications for the position of appraiser, correct?
Madam Chair, I believe you would be correct. It would, but it would be the public policy decision of the legislature or the requester requesting such a bill draft to provide for the election of county appraisers, whether they wanted to change the current statutory language regarding requirements of the county appraiser. If the legislature were to feel that it would be nearly impossible, then that, yes, that particular statute would, the reviser would likely recommend that be amended as well to whatever the will of the body were, to provide however the requester legislature decided they wanted to handle that.
Thank you. Thank you, Madam Chairman.
Representative Turner.
Thank you, Madam Chair. Who is it that verifies the education, licensing, and credentials of these folks?
It's the Division of Property Valuation.
Thank you.
Welcome. Any other questions? Seeing none, thank you, Amelia. Next is Bob Kent, the Director of PVD, recently appointed. And welcome to the committee, Bob, and congratulations on your appointment.
I'm sorry. I apologize. One of the things we talk about is what I like to talk about is the CAMA system and the fact it's installed in 105 counties in Kansas. So, we have all the counties in Kansas using the same platform. We have all the counties using the same cost system. In my mind, if we didn't have that and we had counties that were randomly using whatever program they wanted to use, a Big Chief tablet, whatever it is, multiple programs out there with multiple cost systems, to me, that doesn't lend itself to uniformity. So I think we've got, in the state of Kansas, I think we have a big head start on uniformity. It goes much deeper than just having the system in place and in 105 counties and the same software and the same cost system, but because there's a lot more that goes into an appraisal than just the system itself. But our system is the system's referred to Assessment and Tax Pro. It's a program developed by Tyler Technologies. It does incorporate the Marshall Swift valuation system. That's the same costs that fee appraisers use for bank appraisals, real estate financing, and things like this. And for the most part, our CAMA system is set up for real property. The exception to that would be mobile homes, manufactured homes that we can value through the system, but we can also flag that they're personal property if that's the case. Amelia spoke to the three approaches to value: the cost approach, sales comparison approach, and the income approach. And so, yeah, the market approach of an improved parcel can be estimated by the sum of the land and the value. The estimated depreciation value of the improvements. When we look at the cost approach, you mentioned the replacement costs. The replacement cost is the cost to replace it today, and the market value could be the replacement cost less the depreciation of a structure with the land added back in. Okay, so that's kind of the difference between replacement costs and replacement cost less depreciation, okay, as far as the improvements are concerned. The sales comparison approach is where we take sales of like properties and make adjustments to those sales to make them more similar to the, adjusting for non-similarities between the sale and the subject property. So it talks about competitive properties recently sold in the marketplace, and so it's a comparability type approach. And then the income, and those two approaches are typically used for the residential properties. And then we have the income approach that could be used for commercial properties. But it says the value of an income-producing property is estimated by converting anticipated benefits from the ownership to the income-producing property. And so what we're doing is we're taking when we talk about the income-producing capabilities, we're talking about rents and not necessarily a business income. So I have a downtown retail store or a retail strip center or whatever it might be that rents for a certain amount of money, generates income. If we take that income, that rental income, and we can subtract out the operating expenses it takes to operate that and generate that income, and we can arrive at a net operating income and capitalize that income with a capitalization rate, then we could transform that income, that net income, into a value. Okay, and that's kind of the income approach. Every parcel in the system gets a cost value, replacement cost new, and depreciation's established, as far as I know, for every property. Even for vacant land, we have a cost. I mean, it's land, but we have a cost approach. It doesn't involve Marshall Swift. It involves a computer-assisted land pricing table, but we get a cost approach. And I would say with the caveat, and if there's state-appraised utility properties in the system, they don't get a value from us or from the appraiser. They get a value from property valuation that's certified directly to the clerk. Okay. Amelia talked about some of the duties and PVD's responsibilities. I have some information on that as well. But the county appraiser is responsible for inventorying and maintaining the records in the county. They annually supervise the listing of all real and personal property, again, except state-appraised utilities. Annually appraises at fair market value as of January 1. And again, that fair market value caveat to agricultural land and some, well, for real estate, it would just be agricultural land. But then Amelia talked about the commercial industrial machinery and equipment and certain motor vehicles as well. She spoke to fair market value. I don't think I need to repeat it. That's embedded in 79503A. She talked about listing and valuing properties in a uniform and equal manner. The reinspection process, which is outlined in 791476. The appraiser notifies the taxpayers annually of the appraised values, and with that, they are notified of the appeal rights. And those conducting appeal hearings is covered under 791448, at least at the informal level. They prepare and certify the final appraisal roll to the county clerk. That's covered in 791466. So as far as valuation appeals go, any taxpayer may appeal to the county appraiser within 30 days after the date of mailing of a CVN or a change of value notice. Again, that's covered in 1488, 79-1488. The county appraiser shall arrange to hold an informal hearing with anybody that wishes to appeal. It's the duty of the county appraiser to initiate the production of evidence at the informal level and to substantiate the valuation of the property, including a summary of the reasons the value increased over the previous year. I would like to mention, this talks about an increase in value. A value does not have to increase from one year to the next for the taxpayer to be able to appeal it. It could stay the same, and the appeal rights don't change for a taxpayer. They should convey any assumptions used by the county appraiser to determine the property value. One of the assumptions we talk about when we talk about assumptions is an extraordinary assumption that when we see a property that we can't get on the inside of, and typically we don't, for residential properties, we aren't able to get on the inside of properties. We judge the outside of we judge the inside of the property by what we see on the outside of the property. So we refer to that as an extraordinary assumption, and that's the best we can do as a mass appraiser, unless we are invited on to the inside of the house and are able to get information. We can get information off of websites, MLS. They'll have interior photos and whatnot out there that can be used. I think you have to use those with caution, but that information is available. Talks about the applicable data evaluation sheets being provided upon request. For each of those approaches, we have well, first of all, we have PRCs, property record cards. We have cost information sheets, which outlines the cost approach. We have sales comparable sheets, which details the sales comparison approach, and we have income cost sheets that detail the income approach. In my presentation, I'm going to show those to you so you can kind of see them, and they're very, in my mind, very well thought out, very well presented in the system. And one of our goals at PVD is to try to make some of that information or the understanding of that information a little bit more transparent to the taxpayer. We're working on a couple of different things right now with the comp sheet anyway, and just so they can better understand it. And then at that informal appeal level, if a taxpayer misses that initial informal appeal time frame, they always have the opportunity to pay under protest at two different times during the year: the first half payment or the second half payment if they miss it. So there's more than one chance to appeal, but you can only appeal once at that informal level. So as Amelia stated, county appraisers are appointed by the Board of County Commissioners to 4-year terms. The most recent term just began July 1, 2025. And again, to be appointed county appraiser, candidates must have at least 3 years of mass appraisal experience and be qualified by the Director of Property Evaluation as an eligible Kansas appraiser under 19-430. And all county appraisers are regulated by PVD. I think I heard something, a little question there, but I think that could be said. PVD reviews, we do review the procedural processes that the counties go through annually. There's a lot of different phases to the appraisal process, and we break those phases down. Through the procedural compliance process, we want to make sure that counties are following statute. We want to make sure they're following our guidelines, and we want to make them be USPAP compliant. Their appraisals be USPAP compliant, and we do a lot of work to help them do that by providing templates, and I'll talk a little bit more about that here in a little bit. But we do review that stuff. We also, Amelia spoke to the sales ratio study. We are required to perform a sales ratio study annually. So we do that. I did want to mention, there's been a lot of talk in the past few years about the residential property values and the increases that we've been seeing. And yes, property values have increased in the last 4 or 5 years. The most recent official study that was completed for the ratio study, the 2024 version showed an average statewide residential median ratio of 86.8%. That number is, our threshold that we like to see and our standards are 90 to 110%. So if that appraisal, 90 to 110, 100 being what we would consider perfect market value, I guess. So thinking about 90 to 110, we're statewide, and these are not weighted, but statewide, just taking the average of the 105 counties, it shows that we're just a little bit undervalued on residential property statewide. It probably paints a little bit different picture if you go into each individual county.
Sorry, Bob, but when you said that we're undervalued on the average statewide, we hear from our constituents, and
No,
Yeah.
all I'm conveying what the study shows. I'm sorry.
I understand, but that's why you got the chuckle up here.
Yeah,
But,
yeah.
So.
No, I
thank
get it.
you.
I get
Yeah,
it.
Yeah.
I get it. And we have 46 counties, or 43.8%, had a median ratio of 90 or greater, with the highest being 98. A total of 59 counties, or 56.2 of them, had residential median ratios below 90. And I focus on residential because I think that's where a lot of the concern is with the residential homeowner. So I didn't put anything in here on commercial, but county appraisers, appraisals are performed in conformance with the use PAP. I think that's outlined in 79505. So what, some of the things we do to help the counties, we do hold about 70 classes a year. We have courses on various topics: depreciation, market modeling, our sales comparison approach, the income approach, land valuation, all these things, personal property, oil and gas. And while we hold about 70 classes, we don't have 70 separate classes, but some of these are multiple occurring classes. But so we hold a lot of classes and put on a lot of educational opportunities. We do have appraisal directives in place for guidance. We have about 30 directives currently, and those are on our website. We have 5 appraisal guides. We have oil and gas. We have feedlots, grain elevators, personal property, and affordable housing. So those things lend themselves, I think, to assisting the county appraiser and hopefully providing for uniformity. If I could, I would answer the question about the oil and gas certification, if that's okay. There is no separate certification for oil and gas appraisals in Kansas. I would strongly recommend anybody that is an employee of a county, whether it be the county appraiser or the employee, to engage in our oil and gas valuation classes. We have, I think, 2 different ones. One's the basic introductory course. We also have an advanced oil and gas course. And but there is, to my knowledge, there's no separate certification or anything like that. We do set out a lot of valuation templates. I'm going to show you just a couple or 3 of those here in a little bit, just to show that we get these sales in, we spit these appraisals out. There's a lot of legwork that goes into the appraisal to get to that end change of value notice. And I just kind of want to give you a picture of what something like that might look like. And then. Of course, I already spoke on our educational workshops and our courses. So maybe I could take questions now before I start on a demonstration, a little overview of the system.
That'd be fine. Committee questions? Representative Francis.
Thank you, Madam Chair. I represent a county that has had appeals of several large industrial process plants. What is it in our system? I do understand that these plants are probably very difficult to establish value on to begin with, but what leads to the problem where the county has this value? You know, the company comes in and protests the value, and there's just these huge variations that really create uncertainty both for our county and our constituents as far as what their future tax liabilities are going to be when these plants have these huge decreases. Are we doing something wrong, or how do we improve that process? Is it, and one other thing, just real quickly, I've always assumed that it's part of the problem is the definition of business and machinery equipment. Am I wrong, or are there some other things that enter into that?
I think, I'm not sure the definition is necessarily the problem, but how we interpret that definition and how we look at real property versus personal property, to me, is complex. And there doesn't seem to be, I mean, there's a lot of disagreements out there. One taxpayer might feel one way where the county feels another way. I know that's the case in, obvious case in your county, because I'm a little bit familiar with it. But, we do have the three-prong test. I have, Senator Tyson approached me about this earlier this morning. I do have somebody that could probably lend a little bit more information, more accurate information, better information than I can provide coming, and we might be able to address that a little bit later, but it might be better coming from them.
So is it something that can be statutorily defined in a better way to give more certainty both for business and for our local governments?
I'm not sure. I just think there's with the SEMA, I just think it's commercial industrial machinery equipment. I think it's, I just think there's a lot of gray. We do have the three-prong test. I'll let staff address that later if that's okay. But I don't know if there's anything in statute. I'd have to go back and kind of probably look at the SEMA statute. So.
I think sometimes we set up our procedures based upon historical boundaries. And in rural Kansas, is the county the right size of district to give, to establish values? Should we go more to a district system in some of our rural areas? I'm sure Johnson County is.
Yeah.
They've got the massive transactions.
Yeah.
Yeah,
I think, Representative Smith kind of alluded to this earlier, but we have a lot of counties that have more than one, a lot of counties that have more than, a lot of appraisers that have more than one county. They're not necessarily a formal appraisal district, but they're just employed by two different counties, maybe side by side or whatever it might be. When I think of an appraisal district, I'm thinking of maybe if I take three counties and I have one appraiser, those three counties are sharing the cost of that appraiser, the benefits of that appraiser, the oversight of that appraiser as it pertains to the counties themselves, not necessarily the appraisal oversight, but all other things. That's kind of what I look at when I look at an appraisal district. So, and to my knowledge, we don't have any appraisal districts in Kansas at this time.
No, and I think Representative Smith brought up a good point that we need to take a look at that on making it a simpler process so that maybe more counties would take advantage of that. But I think that's a good thing to delve into deeper. Any other questions? Representative Long.
Thank you, Madam Chairman. Thanks for being here, Bob. I had a question concerning your appraisal guide. It's not really a question, it's more of a comment. 7 or 8 years ago, our county, 4 or 5 of our counties in that region were subject to a lawsuit brought to us by 4 or 5 gas companies that PVD had an appraisal guide in their handbook that our appraiser could use one of two methods to appraise the value of reserves in the ground. And so in looking at that, in that appraisal guide, in that handbook, they elected to use one method. The gas companies brought a lawsuit against us saying that we should have used the other method. Went to BOTA, went on to district court, and in court, we lost that case. And consequently had to pay back $6 or $8 million. It was quite a few dollars at the time for our small counties. So we were feeling pretty deflated, but our attorney in that process asked the court if they couldn't strike down or eliminate the other method of appraisal that we had used so this wouldn't happen again. And I believe that was done. That did come out of that lawsuit. So as a result of that, the appraisal guide changed, or the methodology changed on reserves only. So I assume that your guides are brought up to date once in a while through either, you know, looking back on them or lawsuits or whatever. Is that right?
Yeah, if there's statutory change or something that comes out of a lawsuit or legal action, we usually get updated. Yeah.
And I would say that you're sending out a directive on legislation that we just passed this year on the personal property exemption. Is that correct?
Madam Chair, it wasn't in the form of a directive, it was just in the form of a memo. We send out an annual memo every year summarizing the changes that affect property tax.
Has that been sent out to the appraisers?
It has. It was sent out.
Would you mind sending that to Eddie so that he can distribute it to the committee members?
Sure.
I think there's a few of them interested in seeing what
And I
that
think it's on
direction-
our website too. yeah.
Okay, that'd be great.
So, yeah.
Any other questions? Yeah. Representative Smith.
Thank you, Madam Chair. If I could just extend Representative Francis's question a little bit more. Do we have any property types? I mean, I know we state, at the state level, we assess like our public utilities, railroads, and things like that. Are there any what I call kind of specialty properties like ethanol plants? You know, I think years ago we had some stuff in the House Tax Committee regarding grain elevators and grain storage. There's a lot of these kind of unique properties that kind of require each county appraiser to be an expert and be able to do that, but then it's kind of inconsistent across counties. Do we have anything that is kind of appraised right now at the statewide level, but then went ahead and assessed at the local level? And could that be a solution in trying to create some more uniformity across and consistency across the state?
Yeah, I don't know. I know a lot of the complex properties like that get farmed out to fee appraisers, and the county will contract with a fee appraisal. But I don't know, you're asking me if some of those properties could be state appraised utilities. I think, I'm not that familiar with the utility statutes, although I'm going to try to explain some things to you here in a little bit. But I do think there might have to be legislative change to redefine what the public utility is. I don't know if they fall under that. Currently, they probably don't fall. They don't fall under that. I don't know what kind of change would need to take place. I'm not an attorney, so I don't.
Right, and I wasn't necessarily saying that they would be included in the utility language, because utilities are appraised and then apportioned back to the counties. I was just thinking if there was maybe a person or, you know, a team of people at the state, at PVD, that could provide the appraisal for these properties that are kind of scattered throughout the state, that would be consistent, essentially kind of be the fee appraiser for the county to get that value back to them, so there was some consistency.
If we had the staff that had that expertise, I would say yes, but I don't think we do. They're very complex properties.
Amelia?
And this is Amelia. I would just like to add there, I can't recall what was going on during this time frame, but in 2014, There were some statutory amendments made beginning at this, these are some new sections that begin at 79.5B01. And they are talking about a little bit different process that may be available to these specially complex, they call them complex industrial properties. And it provides kind of an alternate, it's not an alternate method, but an alternate way to have them, that a county appraiser or the taxpayer may request that the director contract with an independent appraiser to classify and value the property. And there's a process for that. And the types of properties that are listed here as complex industrial include things like natural gas and helium processing, ethanol facilities, crude oil refineries, fertilizer manufacturing, those types of properties. So there is something, I don't know how much it's used, and maybe PVD can share, but there was at least an attempt in 2014.
And that was a result of a similar situation that happened in Seward County on the ethanol plant. It was a fertilizer plant in Senator Peck's district. So, yes, we've had this problem before. Thought it was somewhat fixed, but we'll be looking at it again. Yeah, did you have more questions? Sure, Representative.
Yes, thank you. I just had another different topic. When it comes to the methodology, the three different sales, cost, or income, who determines that? Does the taxpayer get to look at all three methodologies and choose? And once they choose, if they do, are they stuck with that, or can they kind of reevaluate it after a number of years? How does that work?
Well, in large part, the income approach is only applicable to commercial properties or commercial type properties. Residential apartments, for example, are a commercial type property, but they're classed residentially. So anything that's generating income like that would be, the income approach would be applicable to. Cost approach is applicable to everything. The sales comparison approach, we don't have, we use the sales comparison approach for residential properties, dwellings in particular, properties with dwellings on them. So yeah, let's just take the residential valuation. We would have a cost approach, a sales comparison approach, and then there's a reconciliation process. So, you know, you would like to think those two values would be similar. That's not always the case, but you kind of got to look at the market and kind of see which one might be the best fit for that particular property. That's appraisal judgment. And are they bound to that number? No, I don't think so. I mean, if they go through an appeal and they see something and where the taxpayer would suggest something that might change their mind, they can certainly go with the other approach. So, yeah. But there is a reconciliation process.
Okay, thank you. Thank you, Madam Chair.
Thank you. And Amelia, thank you for finding that and mentioning it to the committee. Any other questions? I've got a real quick one I'll ask. So how far can an appraiser go for the distance of an appraisal? And just, yeah.
I look at that. I'd like to look at the property types when I think about that. And you know, the question about going into Colorado, I don't think there's anything that says you can't do that. And I don't know what would be an applicable or an appropriate distance to travel. The county next door. But going back to the question that was raised earlier, can you go outside the jurisdiction to get comparable sales? You know, I think we would encourage that for counties that don't have the sample size needed to accurately value these properties. If you're doing a special use property, it wouldn't be uncommon, I don't think, for a fee appraiser to go to Oklahoma, Colorado, Missouri to find comparables for some of those more complex properties, if there was any that sold. You know, and that's, you know, you talk about those small sample sizes out west and the you know, just the sheer lack of data. They do struggle out there. And I'll tell you this, that you know, in those smaller counties, they rely heavily for especially commercial properties on the cost approach. Because they can't get income data. They can't get the incomes and the rents and the expenses. So they're relying on the cost approach. So
Would you mind giving us an overview on the camera system?
sure,
Great.
absolutely. How much time do I have?
Well, we're running a little over.
Gotta get this thing back there. Yeah, it's going to be pretty small. I'll do my best to, here in a second, I will collapse this and it'll be a little bit bigger. But what I thought I would do is, this morning, is just go through this navigation pane on the left and then go through each of these tabs and maybe spend a little more time on one or two of them that might be a little bit more interesting to you and things you might be interested in. But, so I'm in a parcel right now. And I would like to say up front, this is test data. So anything you see here, you're going to see some quirky stuff, perhaps, but it's all test data. And this particular parcel gets used a lot because they just tend to go to this parcel and mess around with it and change things and just all different kinds of things. So, but anyway, this navigation pane here on the left is a pane that gets us to things that you will see over here on these other tabs. So code files, there's reporting, report setup, reports that are generated out of the system. We run reports from there in mass. CVNs would come out of over here. We have system-wide code setup. We have CAMA setup that's specific to data. We have their codes and just a lot of different things like that. User maintenance, that's the security, where the security takes place. But a lot of the stuff you see over here is going to be, it gets identified here or defined here, and you'll see it throughout these other screens here. So for right now, I'm going to knock that down so we don't see it. So right here, I'm in an Orion session. I'm on the summary tab. The summary tab just brings things together, some of the data together, some of the common data together, just so somebody can see a summary of it. It is non-updatable, and I'm going to get that up there so I can have a little bit more room. But you can't change anything on this screen. It kind of gives you a summarizes the class, the neighborhood the property's in, the property values and the assessed values. It gives you a chance to see the photo, and actually you can scroll and see multiple photos. This kind of just shows you that this is certainly not live data, because these structures are certainly not similar, I don't think so. But so you can't do anything here. When you get over to the general tab, this is again general information that you can see, but it's where you would update maybe the legal description, if I can get to it here. Do I need to? No, there it goes. So it's just late. Okay. So you can update the situs address if you need to, or change the situs address. There's the legal description. The taxing units are all listed. The fact it's an active parcel and not a deactivated parcel shows up. So just general information about some information, but some of this stuff can be updated here. There's also a property link where you can link it to another property. The ownership tab, I think this is where you could update the ownership. Some of these tabs I'm not very familiar with, so, because I just don't use them, but
So, Bob, I don't think we're so interested in those as to how an actual property, kind of, yeah, the appraisal, how that's stored,
okay.
how it's
Well,
impacted, I would
let's jump
think.
over to the appraisal tab and just kind of see real quickly. The appraisal tab is it's the biggest tab by far. So this is where all your data is going to be contained. Land entries, reinspection records. You're going to see buildings. All of your buildings are going to be listed here. So you can see where you have commercial buildings, residential buildings, other improvements, agricultural land on this, and that's why we use this parcel, because it has everything. But so I can just touch on a couple of these. There's, you know, there's a market acre listing. So this is where the market acre land, I need to scroll up a little bit here. So you would see where the acre method evaluation, this is just the listing, not really the valuation, but so could be front foot, could be acre, could be square foot. It just depends on what the land, how they had the land entered. Inspection history records. But anyway, all this, I want to take you through, let me just get you to a dwelling here, and I'll at least show you a dwelling and the listing of a dwelling. This is the listing of a dwelling. You can see it's a single-family residence. It's a 1.5-story style. It's the quality on it's a good minus, and you can. It was built in 1946. If you go down through here, the way Marshall Swift's set up is you have a base dwelling, and then you have component records that have to be listed. So we list components for stuff like exterior wall material, roof material, HVAC, different things like that. And all those things get added into the base value of the dwelling. So if I was to just go over here and calculate this value, and I didn't want to really do that, but all right, well, this will take, but what I wanted to do was see the detail, show you a detail. This is a cost approach, at least as it pertains to Marshall Swift. It'll give you the replacement cost new. Marshall Swift has, we could use Marshall Swift depreciation, but we don't. We calibrate our own depreciation so it's local. So we don't use Marshall Swift that's not local. So you can see here we have a detailed worksheet where the cost is, well, let's see. I think those are, the cost new is $422,743. We're not going to get, because we don't use the Marshall Swift depreciation, we won't get the RCNLD here. So depreciation would be applied to that. In addition to applied to the RCN. But I can go to, let me just see a cost report here. This kind of gives you an idea of the breakdown of, if I can get it here. Okay, so this is, again, the cost breakdown. So you can kind of see, it kind of gives you the same thing, only on this report, you're going to see the depreciated value. So we just saw where it was $422,740. Right here, we add our depreciation to it. It's 36% good. When throughout our system, we always look at the percent good and not the depreciated amount. So we have an adjusted replacement cost new less depreciation of $152,190. Okay, and I don't know what else is on this parcel. I'm just giving you one. It looks like there's 11 pages of this stuff. But what would happen here is you would take this value from the cost approach. You would see the value on the cost approach on a property record card. You would also see the comparable sales approach, the comp sale report. And again, that's probably going to show up on a report somewhere or like the PRC. And these values, you talk about the different values, that's where the reconciliation comes. And you'll have a comp sale value, you'll have a cost value on a parcel like this, and it'll be up to the appraiser to decide which one of those values to use. You can see the cost value here on the comp sheet that's listed on the comp sheet is $203,000. The market estimate or the comp sale value for this property is $295,730. So that's, it's quite a spread, but anyway, that gives you the two values. This, this might be something, a comp sheet might be something like what they would be looking at when they're doing final review on a residential dwelling, okay?
So Bob, does the cost approach also use the weightings that are in this system, or is that, when do the weightings in the system come
No, it
into
doesn't
play?
use, you're talking about weighting the comp selection.
The weightings that were discussed, Bob was so gracious, you guys. He spent a lot of time with us going through the system. And there are certain weightings that can be added to the software, like if there's a fireplace and those weightings.
Okay.
Is that also come into play on the cost approach?
Yes, yes. So back on those component records, you have a base dwelling. Back on those component records, where I talked about the component records, you would list those, for example, right here. And yes, it would add for the cost of a fireplace if you were to add a fireplace component.
And what, I guess, so the committee understands those weightings are subjective and each county sets up their own weightings, right, as to what's important. What I'm trying to,
The weightings you're speaking of are weights. You're speaking of weights for the comparable selection process. There's nothing like that in the cost approach, okay? So in the cost approach, we're taking sales that have sold. We're collecting those through a 3 or 4 year period, 2 or 3 year period, whatever it might be. We're trending those sales typically forward to the valuation date. So we can account for time if there's been any increase or decrease over time, okay? Then we're analyzing the data and we're creating a depreciation schedule, okay?
how many appraisals do you estimate that are the cost approach in Kansas? Just off the top of your head, just an estimate. 25%?
I think,
30%?
I'll be safe and say 50%.
50%
Because I
cost
don't know.
approach. Okay.
And I'm talking about for maybe residential housing.
Okay.
The sales comparison approach is the preferred method evaluation. I think it's more accurate.
Okay. And I don't mean to cut you off,
No,
but
it's
we
fine.
are out of time.
fine.
We're way past, in
Okay.
fact. So, committee, do you have any questions for Bob? And what we can do is bring you back during session or in another interim committee meeting.
Sure.
Yeah, sure. Representative Smith.
Yeah, thank you, Madam Chair. Quick question. Is there a way for the property owner to get this detail on their information? Because like on my home, I get my tax statement. It's a mixed-use parcel. I have very little detail. I don't know if it's accurate or not.
Yeah, I think, probably if you want to verify the information on your property, the best thing to do would be ask for a property record card. It's just general. It's a general listing of the property. And yeah, it should be available upon request. I would like to say there should be no charge if you're getting it for your property. Maybe a charge if you're getting it for somebody else's property, and it'd be a minimal charge. But yeah, should be available to the taxpayer. I think any of the reports that are used in the valuation process should be available to the property owner.
So that's my concern here is that how would an average person, and I don't expect you to answer this, but they're up against this system and the data, trying to say, yeah, my property values aren't what you say they are. And, I mean, it's difficult. We've put the burden on the taxpayer, definitely, so.
Well, I think it's a matter of knowing what to ask for. You know, if they call me and ask me or any of my staff, I think my staff is going to direct them to asking for these reports. And it might go a little bit deeper than that, asking for some of the analysis that took place in establishing these reports. And that's, in my mind, it's open records, and it should be available, especially to somebody appealing a property, their property, you know, so, yeah.
Okay, wonderful. Committee, any other questions?
And that's one of the things we are trying to do. We're trying to make these, you know, especially the comp sales process, we're trying to make it more, we're trying to spell it out a little bit better for the user, for the end user, because they deserve an answer. And it's either out there now or it's coming real soon. So, and that's a step. That's a step.
Very much appreciated, yes. Yeah, like I said, congratulations on your new position. I know you've gone over and above when we've asked for information and data, so it's much
Well,
appreciated.
you know, we're here to help any way we can, and I'm not Ray, so she deals with this stuff every day, so it's just second nature to her.
You did great. I think we were kind of losing people because of the minutia, and we do have some other conferees,
I don't think
so.
you can see it real good either,
Yeah,
so.
no, I think it's great. We'll delve in at another date, so.
Okay, very
Thank
good.
you, Bob.
Thank you.
Yeah. Next up, committee, we have Jennifer Williams. Jennifer, welcome to the committee.
Good morning. My name's Jennifer Williams. Thank you for the opportunity to be here today. I know you have a very large packet in front of you, and I know we're not going to dive through that, but since I am giving you numbers and information and statistics, it's easier processed if you have that in front of you, and I will give you an overview of the points that I'm showing so that hopefully in your own time you can look through those spreadsheets to recognize the concerns. I'm really glad that this came right before me because what I'm seeing, because of the ability for the appraisers to fill in the numbers that are necessary, that we are seeing a disproportionate shift and not uniform because of the variances. Some of the information, as you just saw, the ability to give the percent good. My home is 112 years old, and they say it's 77% good, and my neighbors across the street is 30 years old, and it's 88% good. So percent good is an opinion, as is land values, which I will get into, the amounts as Senator Tyson referred to for how much a bedroom's worth, a bathroom, a fireplace, which comps are used. I know I'm on the county line between Miami and Johnson County, and my appraiser will use a property 20 miles away in Paola or Lewisburg before they'll use 1/2 mile away in Johnson County, even though by law they're able to, and the market is more indicative of actual market value, they'll use different comps. And so, again, that's an opinion. Also, condition, desirability, and use, so CDU, whether they have it as good or fair or average, those are an opinion. And so just to lead into this, the appraisers in July were reappointed, and when our Miami County appraiser came before our commissioners, one commissioner asked, may we review your data that you're putting into the software, because we've had an unprecedented number of appeals and the people are winning the appeals. And she dug in her heels and said, no, I've been using these numbers for 5 years. I play with the models all the time, and I'm very happy with my numbers. And so what I'd like to lead in with that, there's a summary of 6 main points. Again, I might not get to all of them, but briefly touch on some. The first concern, property valuations for base acre. So I am unincorporated, and so the Northwest Miami, Southwest Johnson, I have data for those numbers. Miami County used to be similar to Johnson County back in 2021 before we started seeing the large shifts, and we were somewhere around the $15,000 to $18,000 an acre for a base acre calculation. In 2022, that went up to 33,000. In 2023, that went up to 60,000. In 2024, that went up to 66,000. In 2025, it's leveled out at 66,000. Johnson County is still using 18,000. So, and they have valid sales that has been happening on the Johnson County side of the line that they are comparing these with. And so if you look at item 1, page 4 is just a appeal that I won. They came in and said that the 0.4 acre lot was worth $37,000. BOTA corrected that. It was $8,600. So how many people are appealing the value of their land? They know to go to their building, their home, the number of bedrooms, number of bathrooms, things like that, but the land value is in question. And then next page 5, it shows you a 1 acre lot just half-mile north in Johnson County had it appraised at only $8,222 an acre for a full acre, just to give a comparison. On page 6, as you're reviewing it on your own later, I put a map overlay. The white map there is Johnson, and then the darker one is Miami. That's from the Ames and the GIS system. So you can see that arbitrary county line at 215th, what's happening on the north side in that department versus what's happening in the south side. If we flip on over to page 7, you can see the Johnson County numbers that I referenced as you look at it on your own later. That dark green column, 13,000 an acre, 16,000, 18,500, et cetera. But if you look at page 8, you can see Miami County, $66,000. And so that's when we really started seeing some things here when they started changing that land value. And so if you flip to page 9, again, you can see it on a map. So the base acre just helps them to get their calculation, but there's a base acre, there's a residual, and then there's an undeveloped. And so just because they're using 66,000 doesn't mean they're taking 10 acres times that. Maybe they're taking 4 times the 66, and then they're using the residual and the undeveloped. And so the map on page 9 just shows you a summary averaged out amongst the land. Johnson County at 14,000 an acre, 16,000, 17,000. The next page shows the overlay of Miami County. 91,000 on a farm site, 25,000, 34,000, 37,000. Again, these are all on the same street within a mile radius of each other. Page 11 just shows that Johnson County does have a lot of recent sales, and so they do have information they're basing their data off of. Page 12 shows you that Miami County also has some sales, but you can see how they're weighting it on the land as opposed to the building. And again, the land weighting concerns me because if you're taking away people's ability to appeal their building, you're padding that land, you're preventing them to be able to prevail in an appeal. If you just say, no, that's the land value, that's how we set it. Page 13 just shows you some of the variances of base acres that Miami County is using, 66,000, 41,000, 53,000. The next page shows 76,500. If we flip over to page 15, that was just a summary of the most expensive land that's sold in our area is a brand new farmhouse community that's $1 million, clubhouse, paved roads, not the regular rural property that we have. It's something on the Johnson County border. They're getting about $60,000 an acre for that brand new stuff. So why are the others being used when we're more rural property? And when I did the appeal for the land in the beginning of this, one thing they said is, oh, that's a different neighborhood than yours, so we don't use that neighborhood. So they did confirm that that's not valid comps. If we look at item 2, I want to get further into this base land acre and how it affects the appeals. And so on page 16, you'll see in my 9 square mile area, I've been running a spreadsheet since 2021 that wasn't even related to property tax. But since then, because I have the data and the system only goes back 2 years, I've been able to track the changes in the land and the homes and see what's happening. So in this 9 square mile area of 144 samples I have, in 2021, our land was valued at $9,496,700. In 2025, our land is valued at $28,462,730. And so 3 times as high on the land value. And you can say, well, land has went up and everything else, but what you'll find, 17, 18, 19, I'm just letting you see each individual property that makes up that number and how going across the line from 21 to 25 it changed so you can see the pattern. But if we flip forward to page 20, in 2024, the land value increased $3,756,550, and in that same year, the home values decreased $3,028,890. So if we are in a market where prices are raising, and this is inflationary, and this is just the cost of things, what other homes across the region for that many decreased $3 million? And again, it's to keep up with the algorithm. And so I stumbled across this. If you look at page 21, I stumbled across this as I was recognizing some numbers, and then I started putting in percent change. And in 23 to 24, when those values decreased so drastically in the homes, the final total value was 5%, 5%, 5%. And so the land increased 10%. They set the parameters within the algorithm. We want our land increased 10%. We want our total value to be 5%. And then what's left over is what had to happen to the home. It's very similar to what's happening to the farm rural properties, which we'll get into at the end. If you look again on page 21, you'll see in 2025, 6% was their designated number. And that matches what our appraiser told the commissioners at the review at the beginning of the year, that it looks like we're going to be at about 6% increase in the rural, and her algorithm was correct. That is what most people saw. And so again, you can see it based off of each individual property. We can flip over to page 26. And I pulled out some appeals to understand that better as well, because again, in 21 to 22, we had a lot of increases, and so much that a lot of people didn't like it, but they didn't say anything about it. So we were seeing 40% increases in some places. And so in 2023, when those double-digit numbers happened again, I'll say the Miami County citizens revolted. They all came together. They had town halls. They started asking about the process. They started trying to understand it. And again, as they were seeing these numbers changing and these double digits, and so in 23, a lot of people did appeal. It was unprecedented. 22, not as much. 24, not as much. And in 24, it was because their home values went down on the record. So, yeah, their appraisal went up 5%, but their home value went down, so why appeal that? And so, but in 23, I have two different samples of appeals. One is 37 for the whole 9 square mile, and then another one, there's a 30-plus-year-old community that's 3-acre homes, and that they don't have any amenities. They do have their HOA, but 60 homes in there. And in 2023, 30 of them appealed, and they won, and they decreased the valuation $1.7 million in the home just for that community. So my question is, if the other 30 had appealed, and then if they hadn't appealed, and we'll see on a graph in a second, I'll get into that, but if they hadn't appealed, would they keep getting the 5% and the 6%? And so on page 26 is a summary of those spreadsheets, and I have the raw data on the spreadsheets. I'm happy to email to anybody. You're welcome to that information. Sometimes it's easier to see the cell calculations if you can click on it yourself. But in the 37 appeal samples, 2,014,160 overvalued in the homes. And if you look, just jumping forward for a second to page, sorry about that, the number didn't print, but page 29, in those highlighted pink columns, I have the home change from pre-2023, so when the original numbers came out in 2023 to the final numbers after they appealed. In this neighborhood, you'll see the 2 million increase in homes. And I wanted to see, where are we at now? If those people had not appealed, where are we now? In the 2025 home valuations, we are still $915,700 less than the original numbers they brought forth in 2023. And so that shows, again, that how inflated that 2022 and 2023 was. And another question one would ask when looking at the statistics, if in 2023 we decreased homes by $3 million, how high were we overpriced in 2022? So as these adjustments started taking place in that 22 and 23 time period, and now we're trying to get it leveled back out again, it just shows, as you can look at each person's home, one person's home decreased $103,000. I mean, that's not indicative of the market, and it's just showing what happens when we have weighted values and algorithms making decisions as opposed to real comps. And again, on the page 28, there's some gray areas. You can see the algorithm 555. If we flip forward to page 30, where there's some pretty colored graphs, you can see that Timber Trace subdivision I was talking about is 60 homes. You can see 2021 to 2025 numbers to see where I'm showing you that in their neighborhood of 60 homes, their 2025 values are $30,012,000 versus their pre-appeal 2023, which was $30,033,000. And right below that is their post-appeal, where their dark green column dropped almost $2 million. What would that number have been if everybody had appealed? And then you can also see the one to the far right to see how drastic their land values are in that neighborhood alone. In 21, it was $3.6 million in land, and in 25, it's $14 million. And so you have these 3 acres, large lot subdivisions that they're not getting the residual values applied. They're not getting the undeveloped. They're getting or in their case, $76,500 times all 3 or 4 acres that they have. And a lot of times the appraisers will say, well, we make it higher for the first base acre, like in ag, for example, when your farm home site sits on just 1 acre to cover the cost of the septic or things like that. But a septic system doesn't cost $180,000. And so moving forward, for time purposes here, there's some charts and graphs and all that you can look at in number 2. But I just want to review a few more things so I have time to get to this ag. Number 3, I was researching and I found the Appraising the Plains newsletter that our appraisers have here for the state of Kansas. The prior Lynn County appraiser was the president at the time in June of 2022, and she made the post about windshield time, and she said, the thought for today, an appraiser's job is trying to measure something that seems to be immeasurable. We're trying to measure human behavior with the market over the past few years, and as humans, we try to predict, to make our best possible guess, make our best estimate of what we think might happen in the future. Appraisals are based on sales. They're based on historical, not future. And I can tell you that as January 1st of that year, that is a concrete date. I have brought sales to appeals from January 15th, and they said, no, that happened this year. Even though it proves that the value wasn't what they said 2 weeks before, they said that is not correct. That's the next year's number. So there should never be predicting future. Predicting future is what gets us into these algorithm problems. Also in that appraiser newsletter, there's some things there about the market, how they were expecting decline because of the increase in interest rates. And again, you know, that fair market value statute gives you the ability to ignore inflationary periods. And when we're in a situation right now where interest rates are so high that people can't sell their home because they would have to double their interest rates and downsize. They can't afford to move. And so you have limited comps. To base every single property in the system as if we are limited on supply now has inflated every single property, because if they were all to go list tomorrow, no longer are we limited on supply. And so that's a tricky situation, which is probably why they've been given the ability to ignore those inflationary periods, because it's not a true reflection of market value if you've appraised everybody at market value as if there wasn't enough supply. Number 4, just briefly, what I found, they have a time-weighted value. So on the comps, one can sell in November of 1 year, and by January they've already upped that sale price that they're using for the comp based on a time-weighted value. So they were using 12% in Miami County for quite some time for those weighted values, even though the NAR and KCRAR reports were saying 5%, 6%. And so what that means is they were inflating the sale price that they went on to use with the comp, all because it sold a few months later, or a few months before that January time. And had that still been on the market, houses don't go up in that few month period, they go down typically. And so to immediately turn around, there should be some type of a time frame they're allowed to apply a time weighted. Otherwise, we're inflating the inflation and we're leading the problem instead of trailing it. Quickly on 5, the comparability numbers, we talked about this before. Anything over 100 is typically not considered a good comp. Interestingly enough, after that was brought to public light, the numbers this year were less than 100 in the rural area, but it was the same comp. So not sure where they come up with those comparability factors, but they've corrected it in the system somehow. The final one is also a very important one, is our farm and agriculture savings is diluted under the current system. So yes, this ag land is set by the state, and that's wonderful. If you look at page 53, you'll see that little skinny sliver of blue. That's all the state gets a say in. Everything else in that chart is weighted by the county appraiser's office. And so what we're seeing, again, the residential land that the home's sitting on, one of the neighbors is $90,000 for his 0.9 acre. That's a very expensive septic system, you know? I mean, that is increasing what his appraisal value is, which is decreasing his ag savings. Another thing we had on page 54, you'll see during this increase in 22 to 23, we had an 88% increase in the appraisal of ag buildings. So someone's 50-year-old barn that was storing hay or fallen down or depreciated, it should have been tore down maybe, is increased. Some people quadrupled in their values in that area of their ag buildings. And again, the three factors within the state's or the county's authority to appraise: the land that the home sits on, the home, and the ag buildings. If they are inflated to a point that it's above market value when you add the ag land back in, that's not in compliance. That's not fair market value. I confirmed that with PVD several years ago, and the ag land added back in at market value has to be the actual market value. If you've exceeded that, then the county's taken those three variables that's within their opinion and inflated it. And so what you can see on number 56, and I'm almost finished here, 56 is my neighbor. He had an 80-acre brick farm home. He built this on his land. There was nothing there before. He's a cattle farmer. He's faced with possibly having to sell his farm, not be able to pass it on to his children. Once he built the house in 2017, it was a $400,000 house. They already have his house up to almost $700,000 now. Again, they have his ag land at about $90,000, or his residential land. His ag buildings have exceeded to the point that when you add his 77 ag acres back in at market value, he's at $1.8 million. And a house just like his a couple miles away, brick, 80 acres, similar size. It has a pond. It sold for $925,000 after 90 days on the market. And so he is being disproportionately affected. And if you look at that last page on page 58, you can see in his tax bill, you know, we always hear counties set the mill levies. The appraisal doesn't matter. The appraisal doesn't matter. Here's proof the appraisal matters, because two houses side by side, and my neighbor is paying over twice the amount for his taxes when he should be uniform. He should be like kind. He shouldn't be punished for his other property valuations just because he has some ag on there. And one final example of that, another property here on page 55. This parcel sold November 11th, 2022 for $365,000, 6 acres. They put 5 in ag and 1.21 on the residential. So November 11, 22, by January 1st, 23, they had him at $458,940. So less than 2 months later, he was $93,000 over his purchase price, and he put stuff in ag. And so by having that ag savings, he should have been the $365,000 minus his 5 acres of ag pulled out at whatever their market value were, and then that land added back in at the ag values. But instead, the other values were inflated so much. And you can see then in 2024, he's still $105,000 over purchase price. And so farmers are being hurt by the current system that we have. There's too much waiting, opinions, and not enough listening and recognizing. If you can play with those numbers in order to come up with designated outcomes, predetermined outcomes, no longer are we looking on a historical system of facts. So thank you for your time.
Thank you, Jennifer. You excellent information and several handouts here for us. A couple. Committee, any questions? Senator Corson.
Thank you, Madam Chair. Thank you for all the work that went into compiling all this. So, I mean, do you have any specific recommendations of what we can do to make this better, to improve this?
So I believe that I have several beliefs on this, and so I'm not going to express my opinion of the solution, because I just wanted to point out that there is a problem. And when we leave these valuations in the hands of people like this, at some point when it's too many, and, you know, there's maybe some counties that are doing a great job, but that when we're looking at all the counties across the state, there's too much room for error for us to be in compliance with our own statutes. So as far as recommendations, I'm not going to give any. I just want to show you that there are problems, they need fixed, and they need to take away opinion and put in facts.
Thank you. I appreciate it. And again, I appreciate the effort that went into putting all this together for us. Thank you.
Thank you.
Thank you. Committee, I thought it was interesting that, and I know we're short on time, but that the subdivisions, the properties within the subdivision had the exact same percentage increase. I thought that was quite interesting.
It actually happened across the entire 9 square mile of rural, so not even within the subdivision, it actually happened in the entire 9 square miles.
That it was
5%, 5% in 2024 and 6% in 2025.
What are the odds?
The only difference in the subdivision was that their land is rated higher, so 76,500 an acre as opposed to 66,000. And that value did stay consistent from 24 to 25. I think they've peaked out at how much they can pad it on that side now.
Okay. Well, thank you, Jennifer. You've given us plenty to digest.
Thank you.
Very much appreciate your work. Next is Eric Estes. Eric, welcome to the Tax Committee. So Eric, Jennifer was the residential side. Eric's going to present the commercial side.
That's right. Yep. Thank you, everybody. Good to be here, everyone. So I'm Eric Estes, President and CEO of Q-Line Foods, Q-Line Texas, and Estes Enterprises, Inc. On those sides, we run and operate restaurants across various states. Primarily in Qdoba Mexican grills, concepts like that, some Caribou's, Paneras. Also representing our family business, my uncle, president of BTI, Buckland Tractor and Implement, where I also hold, a primary job there. Western Kansas, agriculture, and farm and ag. I also have a newly designed committee that we represent, KDDA, Kansas Deer Dealers Association, in which we have every owner and operator of John Deere dealerships. We've recently organized a group and a committee to help us just collaborate, which has been, it's been great. So we represent all 105 counties with that board. So that is basically trying to make sure that we can keep our farms strong, keep our farms safe, healthy. As we know, we're selling corn at 1979 prices right now. So we're trying to do everything we can on every level. We've recently adopted on KDDA as well as BTI and EEI the property tax discussion. So we've incorporated that into everything because property tax, as we know, the evaluations that we're getting in, as well as all of our fellow partners, all of our constituents, friends and families, homes and businesses have just been inflated to a drastic level. And I would say since COVID really kind of reset this whole trend and the momentum hasn't stopped. In my experience, what I also do is I also consult for others. So I have a lot of friends with large groups of restaurants. An individual of mine, he's got 180 restaurants. He lives in Andover, Kansas. He recently signed to build 30 restaurants, and he chose not to do it in Kansas. He chose that about 2 months ago. He's going to do it in the Carolinas. They gave him a great deal. He said he's going to save per asset $20,000 difference per year per asset. He's going to build 30, so that would be $600,000. He'll save a year, $6 million on a 10-year license agreement. He couldn't get that in Kansas. He did try. I'm in counties across Kansas and Western. A good friend of mine is here with his Qdobas, Chuck Stratman, in your neck of the woods. So he and I split. We both have the same similar issues. I have appealed in 28 counties with all of our valuations. And what I wanted to do today was I kept this brief because I also want to leave time for Q&A. I've been in front of quite a few appraisers and junior appraisers over the last, say, decade. My issues are inconsistencies and variations. I will have a store in Reno County that I built to look just like my one in Saline County. The appraiser in Saline County, by the way, he's been great. His name is Sean. He's been absolutely the best that I've had in the state of Kansas. But what my problem is why is Reno County, and I understand mills and how we justify mills, but Reno County for me went from $17,000 in 1 year, and then last year I'm at $48,000. And so if you look at that, and I'm forecasting as a business owner, and I'm trying to say, well, where do I want to be, and how much of a break do I need to make this? Why in Ellis County do I have Hays, Kansas, an entire strip plaza that's only $17,000 for the entire plaza? And it makes no sense to us. And so when I sit with appraisers, or junior appraisers in most cases, very seldom do I get an actual appraiser. And so just go on record. And I know that the junior appraisers are, and there's nothing to discredit a person. I'm only discrediting the system. But they don't know what they don't know. So they will sit there and I will say, well, why do you have my patio? And why do you have Panera's patio and Freddy's patio earmarked as real estate? It's not. It's a piece of concrete just like the parking lot. And when we can look at it. And it only changes until I say, I can't wait to go to Boda because my daughter's here at the Air Force Base and I get to go see her. And they go, I don't want to go to Boda, so here, we'll just help you with, here's this little thing. And so they'll throw me that. The next year, I'm back to where I started, or maybe worse if it's a retaliatory thing. So I'm very used to it. And so I do this for a Ford dealership. We did it for John Deere dealerships, for other dealers, for other restaurant owners. And the reason that I will help them is because they're lost. I had one reach out to me and he said, look, I have 18 stores in Kansas. He's got Lawrence, he's got Manhattan, he's got all these big stores all across. He said, we sent in and we wanted to see if they would talk to us. They sent back that I missed it by one day. They won't talk to us. They can talk to us, but they won't make any differences or changes. So I would like to earmark that maybe we look at an idea of extending that period beyond a 30-day window or whatever that is, because I think that they're confused as what is Boda? What happens if the appraiser doesn't give me a break in my building? And why did I go up 30% year over year over year? It is disheartening. So my friend had to close his store in Hutchinson, Kansas. He closed it, and I asked him for permission. He said I could use the name of his brand, Five Guys Burgers and Fries. He closed it because he got a tax bill on $68,000 on his Five Guys and $20,000 on his Rita's, and he said that was the entire profit of the entire year. So he shelved that LLC. We lost Target in Reno County. We lost Panera Bread, a friend of mine in Manhattan. And we lost a great Deere dealer. You just lost a dealership in Lawrence, Kansas, and Douglas County. That was a massive tax bill. Property tax bill was crazy. And it wasn't the one catalyst, the one issue, but it was the multifaceted issues of it. And then on top of that, he gets this tax bill that's daunting. And he says, I think we should just relocate or think about doing something different outside of this county. And so those are all concerns of mine. When I look at it and I say, okay, is it an inconsistency between appraisers not understanding other appraisers? Am I looking at a square footage issue, like this company or this, say that Reno County, Ellis County, and Sedgwick County want to take my square footage differently. They give a junior appraiser a laser printer or a laser pointer, right? And they'll say, I'm gonna go laser point this. And I'll say, well, your square footage is off by like 1,000. Are you kidding? That's not even close, you know? And I'm sitting here like, I've done this before. I could be the appraiser at this point, I think. But they're like, well, I can't be. I said, it is, you know? Or I have empty space above a loft, right? So I have a 2-story building. There's nothing above it. Tax it just like they're taxing downstairs when I have customers lined up at a Qdoba. And so I'm arguing that that's not usable space. I'm not using it. But they go by regulations. They said, this is what I'm supposed to go by. So there was no like, it was either a black or a white. There was no gray area. There was no like, hey, I'm going to help you out with this, or let's talk about this. So I said, I'm excited to go to Boda. I'm going to go see my daughter. And they said, I don't want to do that. Every time, by the way. So, and I want to thank Boda too. They've been great on our calls. We've had calls every other week, and they've been excellent as far as being attentive and listening to kind of what my experiences are on all of these. I do think too, I've helped mom and pops. I've helped a clothing boutique store. I felt like there was an unspoken bias in that appraiser. He felt like a national brand like Maurice's, a national brand like TJ Maxx can afford it, where Kathy's Closet can't. She's local. And so their tax base on the exact same square footage was half of what TJ Maxx was. So then the real estate agent calls me and says, well, I don't understand why we're so much higher than they are. And so I do my best when I go in, and I try to not speak to bias, but I know that there's some of that there. I try to look at comparables because comparables are all over the place with every single appraiser. So I might get, oh, well, this one's in Kansas City, Missouri, this one's in Leawood. And I'm like, yeah, but I'm in Goodland, Kansas. You know, I'm sitting in Sherman County in Goodland, Kansas. So you're showing me Leawood. They're going to go to the Chiefs game. They're knocking down a huge population, and I'm living off the interstate. So, I mean, obviously there's some discrepancies. I'm not saying that I have all the answers, by the way. I'm just telling you that these are the things that I'm running up against when I hit every single one of these counties, whether it's one of our John Deere dealerships or likewise. When you look at Buckland, Kansas, so where we have BTI, that facility, the valuation on it is enormous. It's beyond $2 million. So if we were to say, hey, we're just going to have to move everything and relocate it to, call it Dodge City, Kansas, or wherever we wanted to go, that building would be worth $200,000. We know that. In my last 3 assets that I have sold of the restaurants, one of them was fairly new. The other 2 were 20 years old. The valuations didn't come anywhere near close to what I've been paying for 10 years on property valuations. So I know that they say they try to be accurate and fair, but my complaint was, hey, I've been paying this for 10 years and I've been going and saying, hey, I'm going to appeal it. I'm going to appeal it. And I really didn't get very far with appeals, and I fell short. I think the closest one was within $250,000 short of what my valuation had been for the last decade. And so Great Bend, Garden City, and Wichita. And so I left those on there from a real estate perspective for 6 months, thinking maybe the valuation is somewhat accurate. I'm just not getting the right buyer. And so I gave it enough time, and I figured, nope, valuations were wrong. This is market value. And so my reality was my actual market value in all 3 of those communities weren't even close to what the appraisers had listed. And I understand they kept telling me this is the formula. This is the formula. Well, the formula is very broken in Kansas. We are, and I don't know if you know this, but statistically, I know Dave can probably speak to this better than I can. We're the top one. We are the single one for the highest rural commercial taxation, which is us. We fall into that category. Number 1. It's not like it's great to be number 1 in basketball and NCAA. I love that, but unfortunately, I'm going to have to substitute basketball for taxes. It's not great. We're number 4 in residential, and so that's awful. And I feel that for our elderly folks and all of that. And I thank you for speaking on residential. But you know, I want to close it because I know you're going to have to get to a lot of this. But I think that as I look at appraisals across this county, across every county, and working with all of my friends and all of our constituents, they're screaming, and they're saying that their valuations are so excessive that, you know, just for me, and I can give you this, my increases on just the restaurant side of 3 of these companies was $62,000 this year. So if I apply $1.10, which I'm going to do, per burrito that we sell out of our restaurants, I'm going to need to sell 56,363 more burritos than I did last year just to compensate for that. Most everyone, whether you're a Starbucks or whether you're a Caribou, or it doesn't matter what you are, you're going to have to look at that forecast and you're going to have to say, hey, I'm going to have to raise prices by that %. So that means you guys, as our customers and our fans, are going to come in and say, well, why are your prices so high? You know, and it's unfortunate. It's the catalyst to it. And I know it's easy for everyone to say, well, just raise prices, but you can't do that for very long and be successful. And as we know, there's a lot of other variables that are involved, you know, because you guys, as you guys know business, you're going to get it from your towel guy. Hey, I'm going to raise prices. And everyone else inside your P&L, your financial statement, and your balance sheet is doing the same thing. But I think if we in Topeka can get together and be able to at least curb and lower and reduce these taxes, not just for homeowners, elderly, disabled veterans, but for also businesses and commercial, I think that application can allow us a little bit of wiggle room. And it will also inspire growth. Because watching guys that live in Andover, Kansas, make decisions to not build more restaurants here is very concerning for us. And to lose a dealership in Lawrence, Kansas, we don't want to be doing that. You know, it's just like, it doesn't really matter what brand it is, but I find that the most help that I can offer are our mom and pops. I helped a little boutique store. Her parents and her were struggling. They don't understand it. We had a young lady that purchased an old building in western Kansas on Main Street because it had been sitting vacant for years. She purchased it for a children's girls' dance studio. She didn't use 60,000 square foot. She put a wall up and only used the size of this room for the girls' dance. And she gets a $20,000 bill for taxes, and she only paid $10,000 for the building. So I'm just trying to reference to you guys to try to understand that I don't really have all of those answers. I know that a cap is necessary. I know that in Texas, I didn't have to worry about that. In Austin, Texas, where I was at UT campus, I knew that we were capped. I knew that at least they couldn't go beyond here, and it was similar to what a CPI would be. So I know a cap is necessary. I also know that, you know, the revenue neutral, I know that that's necessary. As far as how we're going to put it together or how you choose to put it together, I can definitely help, like on the committee, maybe guide. You know, I do have a lot of ideas that will help, that will curb. I wish that there was a way to take values back to like your 20, 22-ish, 21-ish, 20, and I don't know how feasible that is, but to get some reset for not just homeowners, but all these business owners that are like, man, this is a struggle for us. So
Thank you,
we'll
Kelly.
open it up for Q&A.
Would you stand for questions?
Yes.
Thank you. Senator Klemp.
Thank you, Madam Chair, and thank you, Eric, for coming. It's your perspective on behalf of Kansas is appreciated, and all that you do and the family does is also important. So you kind of talked about small business, large businesses. You have a good perspective. It sounds like, if I was hearing you right, you feel like there is, you mentioned the cap, whatever comes of that, it'll be interesting, but it also feels like there's a local element to your comment, so it'd be local and a state level to curb all of the entities that are taxing. And is that because you want consistency on how you're going to budget for your businesses, or what drives that comment?
Yeah, good question. So yeah, consistency is key, right? I mean, if I'm over in Sedgwick County, and you know, I'll speak to dollars rather than everything else, because dollars are generally the most absorbed. So I'm on Rock Road in Wichita, and it's a pretty predominant area. And so I'm paying $18,000 a year to be on Central and Rock Road, 350,000 population, a very busy store. I take that same store and I go over to Reno County, and I stick it there on 17th in Reno County, where I have, you know, 38,000 population. I have much fewer clients to work with, and I'm paying $48,000 a year for the exact same size of building, the exact same square footage. And to me, I didn't run into that in Texas. And I'm not saying that Texas has everything figured out, but I didn't run into that. I ran into discrepancies, but nothing of that drastic of a nature. The other issue that I run into, Clint, was that when I would go to speak to the appraisers, and I would make an informal or formal hearing, I've done both. When you go to make a hearing, they really already had their minds made up. The only thing that ever convinced them to do anything for me was me saying that I like Topeka and I don't mind going to Boda. So that in itself shouldn't be a catalyst. That my friends and families that are confused and they don't understand what Boda is, they know that they sent in a request and it came back 2 days late, so they were denied. They don't know how or what to say to an appraiser. All that they know is, this is very high for my little Be Well herb shop. I can't really afford this. And they feel like, they almost feel like, and this is some of their comments to me, was it feels like it's just being petty. They feel like they're embarrassed. They don't know what to do. And they don't want to come to Topeka. They're kind of like, this is like really intimidating for me. I just want to get my taxes down to where they used to be.
Yeah, I appreciate that. Also, I tend to play in the retail space with my own companies and a freight company. So I hear a lot of the same pain that you're hearing, just in a different part of the state. So I appreciate what you're doing, and thank you, Madam Chair, for your time.
Any other questions, committee? Senator Peck, I know we're running over schedule, and I apologize. That's on me. But I feel like this stuff's so important. You and Jennifer have put so much time into it. And Bob did a great job, too. So, Senator Peck.
Thank you, Madam Chairman. Throwing out some crazy ideas, if you will, because this is an issue that needs to be addressed in Kansas. Property taxes are out of control. I don't know of anyone hardly that disagrees with that, except for appraisers and county commissioners. In any event, you said that you sold some properties substantially below the appraised value.
That's right.
Thinking, again, a little bit crazy, if there was a law passed that county a county had to purchase property for the appraised value within 90 days of when the owner said, oh, yeah, I'll sell it. In your case, would you have looked at selling sooner, or that really would not have impacted? And I know you're speaking from a business perspective, and I'm thinking a little more from a homeowner perspective. But if a county had to, by law, purchase property for the appraised value as set by the county, would that have any impact, or are we just getting really ridiculous here?
I have wire instructions on my phone. They would have got it immediately. So they'd have been wiring me the funds. From a commercial aspect, that would have been a great asset for me. You know, you look at those valuations, you think, wow, could it be that off? And then it wasn't that I wasn't getting offers. I was getting quite a few offers. We used JP Wygant Associates. They were great. Those ladies just knew what they were doing in the commercial retail space, and they kept telling me that it was overinflated for my taxation from the very beginning. Those ladies knew that I would not get or reach any of those valuations unless it was just like somebody just really wanted it because they want to overpay. But I would definitely entertain that.
All right. Thank you, Madam Chairman. Thank you.
Yep.
Any other questions, committee? Thank you, Eric. And it's really difficult to hear that businesses are literally going out as a result of, or like you said, there's more than one factor, but thank you.
There is, yeah.
Thank you.
You're welcome.
Next is Dave Traubert. Welcome to the Tax Committee.
Thank you, Madam Chair. Dave Traubert, Kansas Policy Institute. I wanted to talk to you today about, well, you heard some very good examples, scary examples, frankly, from Ms. Williams and Mr. Estes. I wanted to provide some information that kind of sums this all up and shows the consolidated impact. I want to start with a chart on the first page of my testimony that shows of the last 6 years we have data, the highest increase on existing property, existing residential, everything I'm talking about here is residential, the highest and the lowest. And the county name is irrelevant. We'll get into some county names later. But you see, we were looking at about a 12-point difference between high and low for 2019, 2020, 2021. All of a sudden in 22, we have a 28-point difference. The highest increase, and this is a county average of almost 28%. And the lowest was less than a 1% increase. Ever since then, we've been above a 23-point variance, almost double what it had been the previous 3 years. So that's just to really show the stark change. Now, if you look at the table at the bottom of my first page of my testimony, you can see how some of these counties are dramatically different. And these are all pretty rural counties. So we're not talking about comparing Johnson to Wallace County, for example. You have Lynn County over the last 3 years. The average, and this does not include new construction, by the way, this is just on existing residential property according to PVD, a 66% change on residential property in Lynn County. Adjacent Bourbon County was 19%. What's so dramatically different in economic activity, in supply and demand between those two counties? It was 34% in Allen County. Look at the next grouping. We see Logan County. This is on the west coast of Kansas. Logan County at 30%, Greeley County at 13%. You have Rice at 37%, then McPherson at 14%, Marion County at 28%. I won't go through all these, but Barber County at 13% is sandwiched between two counties at 42%. There is absolute no uniformity in these examples. The next thing I want to talk to you about is on page 2. And I'm sorry if I'm going through this rather quickly. I want to try to get enough time for questions. There may be some. We went back and looked over the last 3 years, county by county, and compared the increase in on residential existing homes to the per capita income change according to the St. Louis Federal Reserve Bank. Now, there's a one-year difference because the Federal Reserve is only has data out since through 23. So we did 20 to 23 for income and 21 to 24 for valuations. I'll just start with the first one on the line. Allen County, a 34% increase in valuation, a 13% increase in per capita income. That's the picture of a property tax increase that is unaffordable. We can debate the accuracy of the valuations. I don't think there's any question that the tax increases that are resulting from these valuations and from the decisions of the local elected officials, these taxes are not affordable. I mean, you look at some of there are some places where the valuation is more than 3 times the increase in per capita income. Wallace County, almost 25% increase in valuation. It's the only county that had a decline in per capita income, according to the St. Louis Fed. These are just not affordable. And now, fortunately, the revenue neutral law that was passed in 2021 is helping. There are some of the folks are helping, elected officials are making decisions at least not to raise the total collections they come in. There may be still some people paying double-digit increases on their individual property. But last year, the decisions that were made for taxes being paid this year, 62% of the local taxing authorities held revenue neutral. They chose not to raise property tax. Some of those are smaller entities, but we're seeing a really big increase in the number of larger entities that are holding revenue neutral. We're up to 48 counties now. There's a map here on page 3 of my testimony. You can see the counties colored green, all held revenue neutral. That's not the entire county. That's just the decision of the county commissioners. 271 cities, dozens of school districts are holding revenue neutral. And so that is really helping. And if not for revenue neutral, all those people would be paying a lot more in property tax. But all this comes together to now tell you there was a question about solutions. And I'll tell you what the public, what your constituents want in solutions. We did a public opinion poll through Survey USA conducted. It was a statewide poll in September. And the first question we asked was people's opinion of their valuations. 46% of the respondents said their values were way too high. 29% said they were high, but maybe not too much above market value. That's 75% saying the valuations are too high. I think it was, 19% said they're about right? Now, that's their perception. It may not be accurate, but that is their perception. And that's part of what feeds into this. Our second question then was, okay, so, and we based these questions off the activity that came up in the 25 legislative session. Both chambers had a version of a constitutional limit on valuations. We asked, do you want one? 75% said they want a constitutional limit on taxable assessed valuations. Only 13% said, no, we don't think that's a good idea. And it's really interesting to see that these numbers don't really vary much, whether you look at Western Kansas, the Kansas City area, it's across all geographical areas. It's also uniform across all political ideologies, self-described. Are you conservative, moderate, whatever? It's all about the same. The next question, we tested the 2 options that you considered, the rolling average in the House and the fixed limit in the Senate. 66 to 17 want a fixed limit of something like 3%, 4%, 5%. And again, same opinion across all geographies, all political ideologies. Now, if you do that, that would make a huge difference to the people who are getting these double-digit valuation increases. But the county's commissioners and the city council people could just raise the mill rate tremendously to offset that. So we also tested a voter input on revenue limit. The question was, should there be some sort of voter input? And the examples we gave were like a supermajority vote of the elected body, or a protest petition, making their decision subject to a protest petition. 82% agree, only 12% disagree. It's really clear where the public thinks we need to go. And there may be a temptation to look at, obviously there was perhaps some flaws you heard about in the appraisal system. There are maybe thousands of flaws to try to address and put some protections in. Your constituents don't have time for us to figure all that out. They're unaffordable today. And so we do need to do something today to provide relief for taxpayers. And with that, Madam Chair, I will be happy to answer questions.
Thank you, Dave. Committee, any questions? Seeing none, did a great job. Thank you.
Thanks.
So committee will now turn our attention to, Bob, we'll go ahead and go with the public utilities. Do you mind giving us an overview on that? We'll probably get back on track here a little bit, so, yeah.
Madam Chair and members of the committee, again, I'm Bob Kent. I'm the Director of Property Evaluation for KDOR. And I will try to be brief here. So, public utility evaluation and apportionment. First of all, what is a state-assessed public utility? Public utilities are defined in KSA 79-5A01, and basically says that anybody, individuals, companies, corporations, associations of persons, brokers, lessees or receivers, that own, broker, or market natural gas inventory stored for resale in underground formations in this state are a public utility, as well as railroad companies. If such railroad or railroad corporation owns or holds a deed or other instrument, an interest in a right-of-way, a track, franchise, roadbed, or track in this state, talks about telegraphic companies, telegraphic message companies, telephonic message companies, natural gas companies, oil or other commodities and pipes and pipelines, electric power, water, if water is sold for profit or the subject to regulation by the State Corporation Commission, and lastly, transportation to, from, or through the state, cargo or passengers by means of any vessel or boat used to navigate in any of the navigable water courses within or bordering upon this state. So by March 20th, any public utility by March 20th of each year has to make a return in writing to the Director of Property Evaluation on forms prescribed by the Director, showing all the information that the Director shall require and deem necessary for the appraisal and apportionment of values of said property. If we don't receive, if the Director doesn't receive that return, the situation could be placed in the hands of the Attorney General, and the Attorney General can proceed against such utility to ensure compliance with the law. PVD provides multiple forms, about 15 or 20 different forms to request information from the utility companies. These forms include general company information, beginning and ending year-end financials and balance sheets, plan account information, personal and real property listings, and other forms specific to the industry. Unit valuation, 795A03 talks about unit valuation and that the director is required to value utilities by the unit valuation method. The director of property valuation shall annually determine the fair market value of the public utilities, both real and personal, tangible and intangible, of every public utility as defined in KSA 795A01. So we basically are valuing the business, okay? So when we talk about tangible and intangible property. The unit value method is defined as an appraisal of an integrated property as a whole without any reference to the value of its component parts. It's distinguished from fractional appraisal, which is the valuation of one of the parts without reference to the whole, and from a summation appraisal, which is a valuation of derived by adding two or more fractional appraisals. Most of the authorities and most of the industry agree the unit valuation concept is the most appropriate way to value property of a public utility located in multiple taxing jurisdictions. And the simple process, it's not simple, but there's a four-step process, is to determine the unit to be appraised. You know, what is it? Is it a railroad? Does it occupy more than one state, or how many states does it occupy? So we have to determine what the unit to be appraised is. Estimate the unit value, allocate the portion of unitary value to Kansas. We have railroad running through 5 states. There's going to be an estimate of value, but only a portion of that value will go to each state, and then distribute the state's value to individual taxing subdivisions. The appraisal is fair market value, just like it is for any other, most properties in Kansas. The statute that covers the definition is 795A04, which is the same definition as far as I can see as the 79530A that we use for most other properties. So these properties are spread out in multiple states, typically. The goal of allocation is to assign a reasonable portion of the unit value to the state. And then once we allocate that value to the state, we have to apportion it to the taxing units. So that apportionment is set forth in 795A25. And it says, after the evaluation of the properties under 5A01 and amendments thereto, accepting railroads, the director of property valuation shall apportion the assessed valuation of tax units where the property is located in the following manner. Says there shall be assigned an assessed value in proportion to the original cost thereof to the land other than the right-of-way improvements and equipment affixed thereto, the vehicles, power-operated equipment, materials, and supplies. And then secondly, all remaining excess valuation shall be assigned in proportion to the length of lines. And then 5A26 is specific to the railroads. After the completion of the valuation of railroad properties, the director of property valuation shall apportion the assessed valuation to the taxing units in the following manner. It's a little bit different. There shall be first assigned an average assessed valuation per mile to the first main track, which shall include the track rights, the right-of-way, franchise, roadbed, rolling stock, telegraph lines, instruments connected with therewith, materials, tools, supplies, and other property used in the operation of the road, other than the structures and improvements on the right-of-ways and the real estate. Second, there shall be assigned an average assessed valuation per mile in each existing or each taxing unit to all other tract located therein. And third, there shall be assigned an assessed valuation to structures and improvements on the right-of-ways and the real estate of the right-of-ways located therein. So when we talk about going back to the allocation, and I think I could say the same thing for distribution, but going back to the allocation, if we're valuing a property in multiple states and we're, it's spread out over a large area, and we have a decrease or an increase in the, say, new construction or whatever it might be in the valuation. That valuation is going to change the allocation. So if, for example, somebody, the way I understand it, if a company builds a new plant in a neighboring state and the value increases by, I don't know, $500 million, whatever that might be, when that's allocated, Kansas is going to get less of that because the allocation, more of the allocation is going to go to that state. So Kansas is going to get less. So the valuations can fluctuate based on what happens in other states within the company. So I know that's been an issue with not only the allocation, but with the apportionment to the taxing units, or it was this year anyway, with one public utility. So I've also listed some exemptions there specific to public utilities for you to consider. I don't know much about these. If we need more explanation on these, I have staff here that can provide additional comment. But this is what I know here. One comment I would like to make is on the back, the very last line there, 79-227, it says new pipelines for crude oil and natural gas, and it says fully exempt. That's fully exempt for a 10-year period. So I don't know if it got cut off or just didn't get conveyed correctly. So they are not, say, a lifetime exemption. So that's what I have for you today. I'll stand for questions.
Well, thank you, Bob. And I have a question on the, so we treat it somewhat like the income if a business has a location in Kansas and outside of Kansas?
Well, the valuation, you're valuing the whole company. Mm-hmm. So in the valuation, the approach to value will be an income approach or a cost approach. A lot of these companies don't sell every day, so the sales comparison approach would be rather difficult. So we kind of stick with those two approaches. And again, if you need more in-depth information on that, I have staff available that could probably explain it.
No, my gut tells me that we'll be looking at it deeper during session. But committee, do you have any questions for Bob? This has created quite a situation down in southwestern, south central Kansas. Besides the Stewart County ethanol plant, we have a gas plant. And I'll let the next conferee explain a little bit why they're concerned and upset. So, but great job, Bob, as always. Information that the committee definitely needs to understand, especially if we try to decide to make changes to any policy. So thank you very much. Kelly Armberger, welcome to the Tax Committee.
Come on up, guys. I also have Jason Osner, board member from USD 332 with me and Jack.
So Kelly, I apologize. We
I
are
apologize.
short on time.
Well,
so,
I understand.
Yeah.
And that's why the written testimony that you received is brief, because I'm usually doing education things, and I know we usually have 3 minutes. So we're going to chunk this in pieces. As you are aware, we're in a situation where our valuation for our district has decreased $22 million over the last 2 years. We went from 77, depending on whether you do general, capital outlay, or all other expenditures, somewhere between 77 to 79 million to 55 million. And what we found out this year in our Pratt taxing unit was that this year's decrease, much similar to last year's, that taxing unit went from approximately 30 million in valuation to 17 million, of which it was Northern Natural Gas Company. And I shared some testimony, and I appreciate the conversation that we've had with Northern Natural trying to understand. And you've heard you just heard testimony on the process. And so part of in our attempt to understand how that could possibly be, what we're finding is that's really hard to find out. And so one of the questions that I believe, I'll let Mr. Osner address it, is part of the process on the allocation is how that comes to be. But our biggest issue, is the first issue is how are those valuations derived, those allocations that come to our taxing unit, and you see a small table, shifted dramatically in that taxing unit in 1 year. I didn't include the other year, but because I think this illustrates, especially when you look at the valuation for the movable storage. And then the second thing is we have access to our local appraisers on a variety of issues, and we've heard comment earlier about the appraisers, but there's access to them. How do we have access and so that we can learn more about how this process works? And that doesn't seem to be an easy, it is difficult, and it was a long process in order to get those answers. And only thankfully, because Mr. Vocek from Northern Natural is willing to speak, did we get some of the answers, and we're still learning. But I think Mr. Osner has a very specific question to share with the committee, and we thank you for the time.
No, you're welcome, Kelly, but I would say that you weren't asking the right people, because I know Bob goes over and above to answer those questions. So next time, call me and I'll direct you to PVD, because I know they will take the time to help answer them. So who did you like to speak? I'm sorry. And I'd like to recognize
Jason
the
Osner.
Committee. I'd like to recognize the Honorable Jack Timish. Thank you for joining us today.
Yes.
So
Thank you. And I do have Jason Osner in the back, and he's telling me just do mine too. For us out there, I'm a county commissioner, and we are on the list of we didn't have a revenue rate. I wanted to make that a point that our county held our taxes. We are on our neutral. But for this deal
however,
here.
that is still a tax increase because the valuations decrease. So I want people to understand that process.
And that is true.
Thank you.
But the point he was making, and we did it, we used some wind energy to pull down our taxes and hold a deal. But for this, we all got a budget. County's got a budget, school's got a budget. When you look at your numbers and you project things down the road for 10 years, we all do that. But we should never figure they're going to be more than they are now. These guys did that. They went out, they budgeted, they did what they needed to do. But then you get 2 years. Last year, we should have been up here stomping our feet. We didn't do it because we, do some good book work, he was able to pull some money, cut some stuff. But there comes a time with all the services that people want and your teachers' wages and your school bus drivers, there comes a time when you cannot squeeze any more out of it. And then you get somebody like Northern Natural comes in and drops the bottom out on you. And where is that going to end up? It's going to end up on those parents' back, those taxpayers, those homeowners, those farmers are going to have to pick up some of this to fill that void. We just want to understand how this could happen. And we weren't pre-warned about it, knew nothing of it. Jason's deal on the way up we visited, if you were storing grain in an elevator, and that elevator is so many bushel, that value does not change on that storage. The price on the grain might change from $5 to $10, but their evaluation of their property tax is not going to change. How did Northern, storing the same amount of gas in a bigger facility, because they have extended it 8 years ago, 9 years ago, I was in Legislature when we walked that field and the gas had seeped out, so they leased more land, extended their storage, and now we're seeing a drop in evaluation. You know, for us, we don't see any change out there. The farmers are still sitting on a gas bomb. Our school, our city is there, and we see a decrease in evaluation. You know, that elevator is not, no matter what the grain price is not going to see their taxes go down. They're going to pay the same amount. We just would like to see or know and be more clarified on how this could happen.
I'll try to wrap things up because I do recognize that we're short on time.
So Kelly, I'm going to, for the committee's sake, and what happened? The gas left the
Right.
state, or they built in another state? And
I can't tell you what happened. There was a software change. And if you'll notice in 2024, that the valuation, that Pratt district, that Pratt taxing unit was sitting at $52 million. And I know that there's formulas for deriving a final valuation. You'll notice in 2025, it's somewhere around $780,000. You'll notice that the gas storage was 52 and it's 26 now in 2025. And so when you put all of the formula together, that caused our assessed valuation to drop significantly. What happens is, then in order to generate the revenue, your capital outlay, your local option budget, and your bond and interest category, those revenues have to come from somewhere, and those come from our patrons. And if we are serious about continuing to make rural life viable, then we have to be in a position, much like you've heard, where for the patrons, the citizens, maybe they need not to be strained so much. We understand that there will be fluctuations, but number two ask is, could there be something where we have a resource within any public utility that serves a local taxing unit where we can have some conversation? Because if you know something's coming your way, you can plan and adjust for it, and you can make studious decisions. If you do not, then you find out in June, oh wait, all of the conversation we've been having with our strategic plan and the things that the community is trying to do, 80,000 of this revenue stream is gone. Or you go get it back and you go put it on your people in the southern part of your district who cannot afford yet another hit. Go ahead, Jack.
Madam Chairman, I'm going to speak to, when Bob was up here and I was listening, believe it or not, he made the comment, and this Northern Natural is spread over Kansas. He talked up 40 counties inside of Kansas. That revenue that we are talking about got split up, and what part of what Cunningham was receiving might have went to another part of the county. You know, so that is the question: is our area didn't change, so how did we lose some revenue when nothing in our area? In fact, they have added some new wells, what are they called? Observation wells. Put 3 of them in, over $4 million each, and yet our evaluation goes down. So, you know, I kind of got a little bit of what Bob was saying, and I understand that part of it, but is that really the correct way when you let a company come in and store gas underneath your deal, and then later on they take part of your revenue away that helps feed your county or your city or your school? That's devastating to a small county.
Jason.
Thank you for letting me speak here real quick.
would you state your name and?
What's that?
Will you state your name?
Jason Osner. I'm with school board member of USD 332. And if for real quick reference to like page 4 on this, it showed where the movable equipment went from 52 million, and we was assessed 88% of that a year ago. And that has went to 18%. And if you do the math backing into that on 2024, if it was at 50, if it was 52 million, then total valuation would have been perceivably 59 million backing into that. And if it was 59 million, all of that valuation then, if you back into what was revised for 789,000, would then be, if we're at 18% today, that's saying that the valuation of their total equipment went to $4 million. That's a major move that nobody knows where it went. And we haven't been answered any of those questions. And I think that's the purpose of being here. And so.
I guess the key is maybe as we look at the general statute and the allocation, the apportionment, is it worth looking into so that it's more consistent for your local units? Because I recognize that money doesn't land in Topeka, that it gets spread out to the 40 counties, the counties, the cities, the hospital districts, the school districts. And so, again, not asking for anything other than the consistency. And then the communication piece. I get hammered at board meetings in the community. Communication. And I understand that. And now I'm on the other end of it going, I'd like some communication. I'd like to have known in January that I was going to see a $12 million drop in that taxing unit, because I wouldn't have sent my board down a facility study path that we'd have to completely pivot in June. Or I would be talking to my constituents about, here's how we're going to make things work and still be amazing at what we do for your kids, but do know that these things will be different in the future, and this is why. So again, it comes back to, does the apportion, that piece make sense? Can it be adjusted? Is there a way, a mechanism? And that's for you, because quite honestly, from what I learned in June, and I'm old, I've done this a while, and what I've learned now, I don't know much about this particular piece. I know about my home ownership. I know something about farm. I know something about commercial, because we've been through some various things. But the public utility piece, that was a completely different beast. And I know that I can be corrected as I learn more. But it still comes back to, it doesn't look right, the numbers in 24 and 25, even though it is because of a legacy system versus a new software system. And we understand that in the situation it is now, that it's completely legal and appropriate for them to use the system to their best advantage. So does the situation need to be changed a little bit? And two, a company that is multi-state, that has a responsibility or provides revenue for the constituents that live in those communities where it does business, should they not be compelled to have a more or a regular mechanism for communication back and forth? Because I wouldn't be standing in front of you right now, most likely, if for the last 2 years, someone from Northern Natural that could help us understand the ebbs and the flows and the whys of what they're doing, I'd have something that I could give to the people I serve in the community of Cunningham, in the surrounding area in Kingman County. So anything else, John? We really appreciate your time.
So, no, I want to thank you guys for coming. I'll ask the committee, do you have any questions? Yes, Representative Long.
Thank you, Madam Chair. So Kelly, help me with the communication part. Did you get the communication in time for this year's July budget?
Well, we had some good fortune because the Northern did re-examine our allocation and apportionment, and one of the buildings had been misallocated or and if I use the word allocated wrong, I apologize, but it shouldn't have been. And so we did get some valuation back. However, in some of the other surrounding taxing units, it decreased slightly. So there is still a human that inputs into this information. What happened is we had our budget hearing on September 8th. We got the number, the change, and we also got the subtractions from the other units, and our auditor and I did our very best estimate for the hearing, and we have to wait until October 1st for those numbers to be certified at the county level. And just for knowing that we had some ballpark to work with, When we walked in July 1st, we thought, oh my, we're looking at about a 7 mil increase. What can we do about that? And you know, when you're at 51 mils, 51 to 58, it's not great. It's not great. It's not great for my employment because I serve the community. They're not going to be happy because I'm the bearer of the bad news. It's not going to be great for the community because it's not. So then you look at, okay, we did the whole thing. We talked to Department of Revenue. We talked to Kansas Corporation Commission. We learned a lot of things. And finally, we're able to talk directly to Mr. Vacek, who's the tax manager at Northern Natural, and learn about their system. And they agreed to do some looking. And again, a lot of emails and very good conversation. Still don't understand how that change from 24 to 25 can happen. And I'll let you refer to that. But what we did then was like, okay, how are we going to toe the line on this increase? So a couple things happened. We didn't purchase some things that we usually would have for the upcoming year, and we carried over some more cash in our supplemental general than we would, so we could pull the supplemental general line down. And we do have good tax collections. Our people pay their taxes. So if we set a tax rate at 96%, we collect 98 to 99, we've got that carryover that we know we don't have the authority to spend. So we had that, and we had a little extra carryover, and we were able to decrease the increase in our supplemental general. We would like to be 100% 1 year ahead in our bond payment. We're not quite there yet, and so we peeled that back just a little bit. So we did those things, and we ended up with a 2.7 mil increase and a lot of explanations to a lot of patrons, and they were very thankful for it.
So when you convert this to dollar amounts, I heard you say $80,000. Was that to USD 332, or was that to the county too, Jack?
No, that would be USD 332. And actually, if you take the decrease in the 20 mils in general fund, and that is what it is. But if you look at our bond payment and our supplemental general and our capital outlay, the total amount of revenue that is less is somewhere in the neighborhood of $230,000 to $250,000. And so some of that we had to recoup elsewhere, and some of it we're just living without. The $80,000 in capital outlay, you're just not collecting it because it's 8 mils, period.
Any other questions, committee?
You know, I want to address too a little bit on that.
Okay, we got about 2 minutes.
It won't take we did have an $11 million hit on our oil and gas, not totally due to Northern. It was due to needing some compressors put in so we could push liquid on down the line. But we have gotten some of that back, but not all of it. So if we wouldn't have lost that, our county would be dropping more on.
Well, we appreciate your work and trying to staying revenue neutral. That's impressive. I know it's difficult right now. Appreciate you guys being here and coming up and telling your story. These are the things that we need to know in order to help improve a system, a process that's in place, that's been in place for I don't know how many years since it's changed, and this is one of the first times we're hearing a scenario like this. So at least I am. I don't know about anybody else, but.
We personally thank everybody at the committee for hearing us out, and we appreciate that. Also, would like to introduce Representative Kevin Schwartfeger, who is also a grandparent, patron, citizen, a member of our district. So we're all keenly interested, and we thank you for everything and listening to us today. And should you have any questions in the future, we'll be happy to come back.
Well, thank you, Representative, and congratulations. It's a new appointment?
For a year I've been, since January.
Newly elected to the, yeah.
Just to mention, this
Will you please come to the mic if you're going to speak? Thank you.
Thank you, Kevin Schwartfeger, Representative 114th District, that Jack Timish in the past has covered, as well as Michael Murphy. This
Don't
does.
call me like Jack does at 2 a.m. in the morning. I'm kidding.
Oh.
I'm teasing. Keep going.
This has been a real challenge for USD 332. It has been a significant negative impact for them to handle this challenge. It's impacted Kingman County, made it a high challenge to overcome, as well as Pratt County in my area. And just as Jack mentioned, it comes in the face of a recent acquisition of an and annexation of extra acres, a significant area of my part of the country. I got to speak in front of the Kansas State Supreme Court concerning this, and they were granted an increase in expansion of their field, an expansion of their pressure, and now their valuations dropped way out of bed.
Representative, I'm
and you're
sure
aware of this,
you're going to
so
get more opportunity.
thank you very much.
I'm sure you're going to get more opportunity to speak on this. It's not the last we're hearing it, it's the first. So I do appreciate it. You can call me anytime.
Thank you
and
for your time.
Jack can call me. We have some great conversations. If I am awake, I do answer, so.
And my wife and my grandson, who attends 332 Orville, is here.
Wonderful. Well, thank you for being here today. You guys, we are off schedule, so I have made a couple of adjustments. Thank you, Eddie, for helping out with that. Bob, I hope that's okay. We're going to go ahead and break for lunch now, and then we'll come back after lunch, and then we'll start with Bob at 11:15. We're going to come back, sorry, 1:15. That's called, I don't know what that's called, 11:15. 1:15, we'll come back for lunch, and then we'll pick up with Bob, and then we'll have Department of Revenue from Nebraska, and we'll try to adjust the schedule accordingly. So hopefully we can get back on target. But thank you, committee. Good work again, and we'll see you at 1:15. Thank you. And we will start promptly. Even if I'm not here, then Adam will start. of our conferees she has a hard 2 o'clock cutoff, so thank you. So we're going to go ahead and get started, about 10 minutes late, but perfect. We waited on Amelia, so no, I'm kidding. I'm joking. She was here. She was absolutely here. They're always here. So committee, we'll start with Bob Kent again. Welcome back, Bob. Could you give us an overview, fairly brief, of the property tax exemption and valuations of renewable energy in Kansas? Great topic.
I can. Madam Chair, members of the committee, I'm Bob Kent with the Division of Property Valuation of the Kansas Department of Revenue. A little bit about renewable energy. The statute for renewable energy is in 79-201-11th. It states for all taxable years commencing after December 31st, 1998, all property actually and regularly used predominantly to produce and generate electricity using renewable energy resources or technologies. And when the applicant for such property on or before December 31st, 2016 has filed an application for exemption pursuant to this subsection, the county in which it is located shall be exempt. If any exemption that was granted under the provisions of this subsection for property when the applicant after December 31st, 2016 has filed such application or the application, such application received a conditional use permit, can enjoy a 10-year exemption. So we're done with the lifetime exemptions because it's past December 31st, 2016. So everything that's being issued now are 10-year exemptions on renewable energy. The first thing, when we talk about appraising these things, first of all, they've made it very simple for us to appraise. We first need to determine whether they're locally or state assessed. And if the project will be providing energy to wholesale customers only or resellers, it should be locally assessed. If it is providing energy to retail customers, selling directly to consumers, it's going to be state assessed. So that will fall under the state assessed utilities. All renewable energy must apply for exemption with BOTA. And if we have wholesale customers only being valued at the local level, those applications will be forwarded by the taxpayer to the county appraiser for the county appraiser's input, which will be then have a recommendation and then be forwarded to the State Board of Tax Appeals. If it is a state appraised utility, considered a state appraised utility, the form should, we have a property valuation, it's a different form, it's retail for retail customers. The form is actually sent to PVD for PVD's recommendation, and PVD will make the recommendations and forward the application and the fee to BOTA to determine the exemption period, the exemption and the period. With these 10-year exemptions under 79-210, the projects are subject to submitting an annual renewal application to the county by March 1 of each year. And when that happens, I believe it's the county appraiser. I don't know, maybe I don't know who at the local level, but the county will review the project to confirm the project still meets the conditions of the exemption order, and the exemption should continue. I think I'm not we don't have an exact count. I think we have about 38 wind projects in Kansas with a lifetime exemption, and approximately 26 right now with a 10-year exemption. And when we talk about solar projects, we have, they came on later than the wind did. We have approximately 38 solar projects, and approximately 5 of those are lifetime exemptions that happened before December 31st, 2016. We're working with the counties. We ask them for their data, anything they can get, and send to us. We're trying to track it. We want to rest assured that because the way these are going to be appraised, that the data is confirmed up front, and we have a copy of it in case, appraiser A is not there anymore, and the local people need to be able to find that information. So we want a copy of it so we can help them if they can't locate it when the time comes. But the valuation and assessment, the renewable energy typically, they don't qualify for the commercial industrial machinery and equipment exemption under 79-223. So if the property provides energy to wholesale customers locally appraised, it's considered personal property subclass 5, which is valued by its situs as of January 1 of the tax year using a formula outlined in 79-1439-2E and the Kansas Constitution, Article 11. So I've given you, the basic formula is it's retail cost when new, depreciated out over a 7-year economic life with a bottom out depreciated value of 20%. So if you look at the graph in the middle of the page, on page 2, just a short example there, if you have a $400 million cost new, and after 10 years, of course, 10 years is after 7 years, so it's going to be, at 10 years, it's already going to be depreciated out at 80% or 20% good. And the third column there, so the total depreciation would be $320 million, and that should say total depreciation instead of depreciated value. The next column should be the depreciated value or the end of life value of $80 million. That $80 million multiplied by the 25% assessment rate gives us a $20 million assessed value. I stuck in an average 2024 rural mill levy, and to give you an idea what the tax might be on something like this. So annually, looks like about $2.5 million. When we talk about the renewables, the towers, and well, any renewable, most the towers and the solar anyway, they are personal property. The sites they sit on should still be valued at the market land value. So that's up to the county as well. If the property provides energy to retail customers and is state assessed, it will be valued as a public utility by property valuation after the 10-year exemption period, subject to 79.5A01. And the assessment rate for public utilities is 33%. Talks a little bit about, again, about the site value there. We do have a directive out on the site values of this type of property, and that is Directive 19038. And then it just, on the back page, it just talks a little bit about the tracking. We have directed all counties to send us that information, like I said. Most of these projects pay pilots, at least the early ones, and I would probably say wind more than solar. But the solar projects also, I understand, might be paying what they refer to as contributions, And there is apparently a difference. I don't know the legal difference between pilots and contributions, but I do know pilots are restricted by statute a little bit on how they have to allocate their money, where contributions may not be. I'm not an attorney, but that's the way I understand it. So, and I found out the other day, some counties are a little sensitive to calling them pilots because no, they're not pilots, they're contributions. So, so they understand. I think there's they're different. So we're trying to work with the counties just so we have that information. But I look at some of the information. Some of it looks like that we have is annual pilots. Some of it looks like it's for the whole project period or whatever. So I'm a little. I think it's something we need to work on at PVD to try to get those kind of beefed up a little bit and more consistent. And I don't think we have all the projects out there yet either. So. And then lastly, there's exemptions pertaining to renewable energy. I mentioned 20111. That's the main exemption. There's a biomass to energies facility exemption, and I don't know these exemptions in detail, but it's up to a 10-year exemption. There's a biofuel storage or a blending equipment exemption, 79232. That is a 10-year exemption. And then 79233 is a CO2 capture sequestrian utilization equipment, and that's a 5-year exemption. And again, 79-223 is the commercial industrial machinery and equipment exemption, but it does not pay, or excuse me, it does not include renewable energy resources in that exemption. So that's why it comes back on the tax roll.
So, Bob, we have a conferee from Nebraska, and she has a hard cutoff at 2 p.m.
Okay.
Would you mind if we asked you questions after she testifies?
Absolutely.
Okay.
Yeah.
That might be good. And she might spark some questions, some more questions for you, too.
Sure, yeah.
Okay,
Sounds
awesome.
great.
Thank you.
Okay, thank you.
Okay. So our next conferee, trying to catch up, Sarah Scott from Nebraska Department of Revenue. Sarah, are you online?
I am online. Can you hear me?
Wonderful. Thank you for joining us today.
You bet. Thank you for having me. All right. I am the property tax administrator in Nebraska, and I was invited to just share some highlights of our nameplate capacity program. So I'll just do a brief review of that program, and I'd welcome any questions that you have regarding the program. We'll get started here. Just a little disclaimer document that this is a guidance document effective today. So our nameplate capacity program came from LB 1048 in 2010. And its purpose was to replace personal property tax that became exempt at that point in time for renewable energy facilities, at that point only for wind generation facilities. Our personal property tax in Nebraska is based on the Nebraska adjusted basis, which is the acquisition cost of the asset, depreciated using the federal maker's class life. So most assets depreciate from 3 to 7 years. Most wind energy assets were depreciating in 5 years, causing a local budgeting challenges for both, we'll talk more about that, but for both the political subdivisions and for the facilities. So this tax was looked to for a stabilizing effect for taxation of renewable energy facilities. Our act specifically indicates that the tax is to be competitive with other states, that it is to be fair and non-discriminatory when compared to other industries within the state, and that it should not be used as a general fund source in economic downturns. So this tax can be found at Nebraska Revised Statute 77-6201 to 6204 for your reference. It is an excise tax. So it's not an in lieu of tax. It's not a property tax. It is an excise tax. We do exempt governments and of course and quasi-governmental organizations from the excise tax. So we are a public power state. We exempt all of our public power facilities from this taxation, as well as electric co-ops, organizations of that effect, and certain customer generators. So the thought with that is that we wanted to incentivize businesses, large electric consumers to produce their own power. So we do exempt from the nameplate capacity customer generators under certain capacity. There are provisions like they have to be generating the power on the customer side of the meter and certain things spelled out in 72002. The tax does apply for facilities that are in commercial operation for at least 24 hours. They must be connected to the grid or to an end user. And then the facility has to have a nameplate capacity of 100 kilowatts or more. And in 2020, we did also institute or introduce the alternating current capacity to accommodate solar users or solar projects. The tax itself, so I should have said nameplate capacity is the the stated capacity of the project. So perhaps the licensed capacity, if you would, the amount the project can generate at the time that it is commissioned. The tax is $3,518 per megawatt. We do assess it at fractions of a megawatt, and we do prorate it based on the number of days that the facility is in operation on the first and last years of operation. We do not, however, reduce the tax if the project is not meeting its actual capacity unless the project is decommissioned. So at the time of decommission, there can be some adjustments for the tax at that point in time. The administration of this tax is fairly simple. It is a self-reporting to the Department of Revenue. Again, the nameplate capacity is the known capacity at the time that the project is commissioned. So there is not a lot of variation. There's no need to capture what is actually being generated each year. It's a simple form. I provided, you can find a link to that form on our website. It's form 424AR. It should be in the electronic copy of the document you received. And then, so that's due to our department, to the Department of Revenue, March 1st. We then very quickly process these forms and assess taxes that are become due April 1st and are allowed to be paid in quarterly installments. We do assess penalties of 5% of the amount due for late reporting, for failure to pay the tax, or for under penalty of tax. And we'll talk a little bit about why that matters perhaps in the end. The tax is collected by the Department of Revenue and distributed to the counties where the facility is located. And then the county treasurer prorates the taxes to each political subdivision that would have received personal property tax had we not exempted it. And so under our statute, their distribution is simply the amount of local subdivisions' total taxes. So all the political subdivisions that would have gotten tax, we add up the sum of their total taxes levied, or in each individual subdivision's total taxes levied divided by all of the eligible subdivisions that would have received tax, and simply do a ratio to distribute it based on the nameplate capacity they receive each year or each quarter. Couple budget impacts. So again, the reason that this tax was lobbied for and determined to be effective for Nebraska is that our personal property tax was going away after 5 years. Right? So our entities were receiving large gains in property tax revenues for the years that the personal property tax was in place, but then quickly losing those funds after 5 years, and they were declining each year with the depreciation. So it was hard for political subdivisions to meet their budget needs with that kind of fluctuation in valuation. Now, as a bit of a compromise, I think when this was introduced and as an incentive to, I think, the counties to accept this form of taxation, the restricted funds budget cap was not a factor. So in other words, the nameplate capacity tax doesn't have to be included in the political subdivision's restricted funds for the first 5 years. So in a sense, it's a bit of taxation that's not limited for the first 5 years that they receive it. And that's so 2 reasons. One, because the projects get prorated as they come in line. So it's often 2 years before they receive the full amount of tax. And it also just gives them a bit of time to kind of recoup that upfront taxation that they may have gotten, not in terms of amount, but it just gives them a time that they don't have to consider that in their budget restrictions. Whereas the facilities like this tax because it's extremely stable. They know what their nameplate capacity is going in, and they expect to pay that amount of tax each year. And so it is a stable form of taxation for both political subdivisions and for the renewable energy facilities. I have just a graph here to show you Nebraska's increase in this tax from the time it was instituted in 2011 to today. It's about a $12 million program right now. Now, just to give you a sense of what that may mean, just some quick Google search shows that perhaps Kansas has 3 times the wind energy investment that Nebraska does and 2 times the solar. So certainly a comparable tax in Kansas would produce more revenues because we have less investment in Nebraska. Just this slide is a little bit of conjecture, but I thought it was useful to provide. I took our $12 million in nameplate capacity tax. 80% of that $12 million goes to 6 counties in Nebraska, and we have 93 counties. So 6 counties are largely benefiting from the nameplate capacity tax. And if you see here, what I've just taken is the average tax rate from last year, so 2024, in those 6 counties that received that tax, and compared it to the state average levy then I took the state average levy excluding our metro counties because the metro counties tend to have higher levies anyway. So what I took from this exercise was that those counties that are receiving this nameplate capacity tax are showing a return to their taxpayers in a lower tax levy, which I'm sure is important for you. It's certainly important in Nebraska these days. Saline County was a bit of the exception. It's worth noting that they're in their first 5-year period. So they're not counting their nameplate capacity as restricted funds at this point in time. I would expect to see their levy drop in comparison to the state average over the next few years. So I offer that for what it's worth. Certainly there are other factors that affect each county's average tax rate, but I think nameplate capacity is at least a portion of that. So just a few quick lessons learned. One is that our tax rate at $3,518 has not changed since 2011. If you institute this tax, I would highly encourage you to put some sort of inflationary adjustment on the tax rate. I think anybody anywhere would love for their tax rates to never change. We have been trying for the last few years to do that. Of course, there's a lot of factors motivating. That has not happened yet. So I would encourage you to start with something like that. I answer a ton of questions about a $12 million program because there's a perception of instability. So I said that this is a very stable tax. It is. Because it's a stable tax, counties literally expect to receive the same amount of money every year. They don't because we distribute to them what is actually paid. So payment situations change from one year to the next. Penalties change from one year to the next. So oddly enough, there is some criticism of the program at the county level because they perceive it to be not stable. The tax is extremely stable. The payment of that is not. Small thing, but worth pointing out. And then I won't go into it because our real property taxation differs for yours with ag land, but if you have questions, I'd be happy to answer them. But what we have seen is disagreements about how the real property component of the land should be assessed as we increase our renewable energy investment in the state. I think that largely comes from solar use for years. And I understand that you give the land under these facilities your ag valuation, your ag use value. we're a market value state, but our ag land gets 75% assessment level. So we were giving that 75% assessment level to the land under these facilities, but as solar kind of changed the picture in that solar is much more dense, solar farms are much more dense on ag land than wind turbines are. Some people thought that was perhaps not fair. So that changed 2 years ago to say that our definition of ag land specifically carves out renewable energy to say that is not ag land. And there's some competing interests in the state discussing now whether that should remain or not. So just a bit of caution there. I don't know if that's completely related to nameplate capacity, but I think that as the renewable energy facilities change, that's one of the things we have seen. Tried to keep it brief so I could answer your questions. So with that, I would be happy to answer any questions that you have.
That was a good presentation. Thank you. Committee, any questions? Okay. Any for Sarah? Any questions for Sarah? It's okay. So Sarah, approximately how many wind turbines do you think you have in Nebraska? Just curious.
So we have 31 wind farms. You can go to our website and get the actual count, and I could count that up real quickly.
No, that's okay. If we can go to the web.
Yeah, you can go to the website. My
get
very
it.
first slide has a link to our nameplate capacity landing page, and you can sum those right from there.
And when did you implement this program, did you say?
2011.
2011, okay. And I know there's a few other states that do a similar tax. Were you guys one of the originators of this, or did you follow an example of another state?
I don't believe that we were the first. I don't know which state we followed specifically. I could find that out and let you know.
Okay. Okay, that would be great, Sarah.
Sure.
Anything else, committee? I don't see any other questions. It's probably a lot to digest. It's, but very interesting and something for us to look at and think about. Thank you again, Sarah, for putting the presentation together and taking the time to join us. It's very much appreciated.
You bet. If you have future questions, feel free to reach out.
We will. In fact, I'm sure Eddie will be in touch with you. So
thank you.
Thank you, Sarah. Bob, would you mind answering some questions? Thanks. Senator Bowser.
Thank you, Madam Chair. Great day to be on the Tax Committee. Thank you, Mr. Kent. I had about 6 questions here, and you answered, I think, 4 of my 6 in your presentation, so good on you for that. And to give you some context, there is I'm very interested in this topic because there's a very large solar project planned for Jackson County. I want to say it's 4,000 or 5,000 acres. It's in the planning process, hasn't been approved, but it is being planned. My first question is, and I'm reading from your renewable energy evaluation paper here, it says, if the renewable energy source will be providing or selling energy to wholesale customers only, the project will be locally appraised. How do we, my thought was that if I produce electricity, I throw it on the grid and I don't really know whether a wholesale customer uses it or a retail customer uses it. But are the energy companies able to determine that? Do they tell you ahead of time this is only for wholesale or only for retail?
Yeah, I'm probably, there's probably people in this room that could probably answer that better than I, but the way I understand it is if a company has a solar farm, they're selling it to, say, an Evergy, who Evergy is in turn selling it to the customer, then it's locally assessed.
Yep.
So, and I don't know, I don't know how we determine that.
Yeah.
But
my other question there was, what if it's a combination of, I don't know, maybe 80% wholesale, 20% retail? Is there another formula used to calculate that tax, or?
I don't know. Have we come across that?
So it's either one or the other. It's either wholesale or a retail? Okay. That's interesting. Okay. Second kind of question here if I'm a rancher and I've got, my ranch land has been assessed at a certain value since the beginning of time, and then the next day I have a windmill or a solar panel on my property, typically does my assessed ranch land value, does that typically go up? Does it go down, or does it stay the same?
When you say, can you describe the system? Are you talking about a solar panel?
Well, I'm talking about.
A solar quote farm?
Yeah.
Okay, so however many acres?
Yeah, yeah.
Yeah.
Does that land value, is it assessed differently after that panel appears? I'm assuming it is, but I don't know whether it goes up or goes down or stays
The way we've described it in our directive is it should be appraised at market value. A lot of counties, I think, will use an ag land market value. But yeah, so you're going from a use value at, which is a fraction of market value, to a market value per acre. So yeah, there's no doubt it'd be an increase.
My land would increase in value?
Yeah,
So I
if
would
it's
think-
going from ag use value to market value, absolutely.
Well, let's say I have a windmill. I can still graze cattle underneath that windmill.
Yeah. Well, okay, so the only thing, so if you have a tower, we're looking at the area that is needed to support the tower. And I think yesterday, I don't know if it was in here or was talking to somebody else, I was just throwing out an acre. How big are these sites? I don't know, maybe an acre.
Okay.
So that's.
So then you would take that acre, that is now non-ag use land, and you would deduct that out.
The county, according to our directive, should value that, whatever area that is, at market value.
Right.
Yeah.
Okay, thank you. I think that helps. And then my third and final question is here. We just heard Sarah from Nebraska talk about an inflationary tax increase. I don't know, is that possible to do here in Kansas? Does our computer system allow for that? What would we need to do to have an inflationary tax increase?
These, I don't think these will go through. Now, you're talking about the structures themselves.
I think so.
Or the land?
Yeah.
Well, I think the land would be at market value, and that's what the statute requires.
What about the renewable energy equipment? Is that the inflationary tax increase?
Well, right now, the way we've drafted it, I believe, it'd be static because it'd be retail costs when new. So it's whatever the cost was new.
Yeah, and plus things are depreciating, right? Their assets are depreciating?
Well, yeah, and they'll be depreciated, yeah, at 20%, down to 20%, yes, yeah.
Yeah, if I may, I think what the key was that Nebraska completely eliminated property tax on these, and that's where they recommend the inflationary. If Kansas was to consider or go to a nameplate capacity, that's where she said that she would consider an inflationary.
Thank you, Madam Chair. Very
Yeah.
helpful.
Yes.
Thank you. Thank you.
Yes. Representative Smith?
Thank you, Madam Chair. I wanted to ask about, you had an example here, a locally assessed example on page 2. I guess I wanted to ask a little bit about the depreciation. Is that kind of industry standard? Where do we get that number? Because you're basically saying that these things are 80% depreciated after 7 years. Seems like they have a much larger productive lifespan than that. That's a significant amount. I mean, the taxable value, once they actually come on the tax rolls, is almost negligible.
Well, I think it's in statute. I think it's in 79-1439 that spells that out. Yeah.
Okay.
Amelia?
Yes, Madam Chair and Representative Smith, it is both in, that economic life is found both in 79-1439 and the constitutional provision
Okay.
for commercial industrial machinery and equipment.
Answers that question.
Representative Francis?
Thank you. And just kind of looking for a comparison between what Nebraska's doing and what we're doing. Do you have any idea what one of these, like a 3 megabyte or megawatt is what they're building out there now. Do you have any idea what the original cost on any of those are?
I don't. You know, I've looked at some of them that we have data on, and they just seem to be all over the place. I don't understand it. Yesterday I was looking at wind, because we have some of that data, a lot of that data on the wind projects, but it just seemed like they were kind of the cost per tower, I guess, is just all over the place according to our records. So
Yeah, I was just looking
and
at.
I really
yeah.
wasn't looking at the megawatts. I was looking at just the tower. But but no, to answer your question about the megawatts, if certain, I don't have any
But we could probably
knowledge of
find that
that.
out then. I was just curious how our taxing compared to the capacity. Thank you.
Right, we could request some numbers to do some comparisons. A rough estimate, if you looked at Bob's sheet, it's about $2,500. And when it came on the life of the project, am I looking at that right?
Are you talking about the grid?
Yes.
I'm thinking
then-
that's 2.5 million.
Oh, okay, I thought that was just one turbine.
No, it's $400 million
Oh,
worth.
okay, you're right.
I just provided an example of a project. Some of these are in the $400 million range.
So
some
they
of the
would
bigger
pay
ones.
approximately $2.5 million a year?
Correct.
Okay,
Yeah.
okay. Yeah, we can take a look at the comparison on the capacities. Well, we would definitely do some, I thought it was interesting, Nebraska does this, Wyoming, Illinois, a couple of states.
I
Yeah.
was familiar with Nebraska, and that was about it.
Okay. Yeah, I've just been researching different, just trying to think outside the box for what's going on in Kansas. But Bob, do you mind providing for the committee, Eddie found the number of wind turbines for Kansas, but could you provide in an email, not today, the number of wind turbines, solar farms, how many were prior to 2006, the 16 life? How many are going to come on the property tax rolls? Just to give us, I think that would help Representative Francis, what you're looking at, right? Kind of a comparison of where we're at and where Nebraska-type legislation could take us.
Just a little bit ago, I gave you a rough estimate, but I don't have, I feel like we need to clean our data up a little bit. But just for your knowledge right now,
Yeah.
I think we have about 38 wind farms with a lifetime exemption, approximately.
Yeah, I'd like to know how many turbines and farm, I don't understand that terminology with a wind turbine and solar panels. I just don't understand. I know that it's like saying we have almond milk. I just don't get it, guys.
So you're asking to break it down by the turbine, number of turbines?
Yeah, the actual
Gotcha.
turbine.
Okay.
Yeah. And Eddie came up with roughly 4,400. And Nebraska, he's amazing how quick he can find stuff, guys. 1,493. So we are considerably more.
right.
And I heard there's quite a few more coming online in Kansas, but I'm not sure with the federal law changes what that'll look like.
Exactly.
Yeah. Any other questions, committee? Seeing none, thank you so much, Bob. Bob, you're back up again. Sorry. I'm so sorry. Appreciate you doing all this. I know it took a lot of time and effort to prepare. Mineral leasehold valuations.
Yeah.
This is a big black hole to many of us.
Yeah.
So,
Madam Chair and members of the committee, I'm Bob Cannon with the Property Valuation Division of the Kansas Department of Revenue. And I'll first let you know that I do have staff here on hand if I can't answer some of these questions you might have. So Oil and Gas Valuation Authority, the director has the authority under KSA 755105 to prescribe guides to assist the county appraiser in the mass appraisal process of establishing value for personal property in Kansas. We do use a a guide to value oil and gas leaseholds in Kansas, and they are considered personal property, and they are covered under 79-329. It says, I'll add the county appraiser is required by 79-1412A and 79-1456 to follow the policies, procedures, guidelines issued in the oil and gas guide by the PVD each year. So oil and gas, they are produced, or the values are appraised at the local level, and this is a self-reporting value as well. It's not self-valued, it's self-reporting. I think somebody questioned me on that earlier. It's just they report their information to us so we can value the property. And I think that earlier conversation was about utility properties. But with their reporting their information, then the valuation takes place at PVD or at the county. So on or before April 1st, the county needs to submit their assessment rendition to the county appraiser. That's covered under 79-332A. And the county appraiser shall appraise the property at its fair market value as of January 1 each year per 79-301 and KSA 79-501. So the oil and gas appraisal guide utilizes an income approach to value through the valuation models with common data to value a universe of properties throughout the state. The guide's mass appraisal model discounts projected income to establish value, taking into account the decline or the lease rate of depletion, the operating costs, and considers equipment value at the end of the economic life, in addition to all the other factors required by 79-331. I think some of those factors are the age of the wells, the proximity of the wells to the market, mentions cost of operation, the quality of the oil or gas being produced, the extent of permanency of the market, the probable life of the wells, and the number of wells being operated. So those are just some of the things that are being considered in an oil and gas valuation. Again, the guide's approach, the information is self-reported. It talks about the January 1 valuation date. Again, so for oil and gas valuations, the price is multiplied by the production to form an income stream. So for oil leases, the oil lease price table is issued by the Director of Property Valuation with relevance to oil gravity and Kansas severance tax effective January 1. So the oil and gas supervisor, we meet with industry every year. We discuss prices. We discuss economic conditions and things like this to set a price for oil that will be used in the guide. Kansas, or gas leases use the prior year's net weighted average price multiplied by a market adjustment factor that is issued by the Director of Property Valuation. The market adjustment factor is used to adjust the prior year's average to today's market conditions. And I think there's a statement in there, although it uses established production, we don't consider it an income tax, sales tax, or a production tax. We consider it a property tax. There's two different interest types. There's a royalty interest type and a working interest. So typically a common interest split would be a 1/8 interest in the royalty and a 7/8 interest in the working interest. You also have an overriding royalty interest, which could surface, and that could be a royalty interest that is taken off of maybe, say, the working interest for access or something like that, and it might be less than 1/8. but still an overriding royalty interest. But the royalty and overriding royalty interest value is based on individual interest in effective gross reserves with no deducts for the operating lease, operating expenses. They do not pay operating expenses, so they don't get any deduction for it. The working interest is based on the effective gross reserves with deductions for lease operating expenses, and then a residual for the equipment is added back in to that number. And then I've listed some applicable statutes and some key dates below there. There is an exemption in 79201T for low production wells that produce less than 3 barrels a day, and oil leases with less than 5 barrels per day if the well depth is greater than 2,000 feet. And that's for yeah, I think that's on production, right? Yeah, it's a production, yeah. So, and then the key dates are just ones that we are familiar with. 1460 is the valuation notice deadline. 1448 is the appeal deadline, or the appeal statute. 1467 is the change of value notice deadline. 2005 is the payment under protest. I would take note to 79332A, which is a filing penalty. Operators must submit a rendition of their oil and gas assets by April 1st, like I stated earlier. The late filing penalties are 2% a month up to 10% and 12.5% after a year. And with that, I will stand for questions.
Thank you, Bob. I know it's a lot to digest, committee, but I thought we should take a look at it since it's taxed a little different than other items in the state of Kansas. Committee, any questions for Bob? Okay. I don't know if it's because the hour's late or. Oh, you're welcome to.
No, I don't.
Oh.
Catching
Okay. Well, committee, Bob, I can't thank you enough for all your effort and work to help get us on track of where we needed to be. So, thank you. Yeah. Next, we have an overview of tax severance from Mark Burkhart. Secretary, welcome to the Tax Committee.
Thank you, Madam Chair, members of the committee. Mark Burkhart, Secretary of Revenue. I am here to give you a very brief overview of the Kansas severance tax. And I guess I have a couple of objectives here. One is just give you a brief summary of how it works, what's taxed, what is not taxed, what is specifically exempted, the lost revenue associated with those exemptions, and then in general what the severance tax means to the state general fund. So, and you're probably wondering, why is the Secretary talking about the severance tax? Well, it's because this particular enactment in 1983, 42 years ago, I joined the department as the first severance tax attorney administering this law. So a lot of the guidance that was issued back then, I was involved with. So again, legislative history-wise, the current enactment that we have was done in 1983, and preparing for this, I realized we actually had a prior severance tax that was enacted in 1957. It's a very simple tax, 2%, no exemptions, and it was struck down by the Kansas Supreme Court the following year. And it's very interesting because at that point in time, there was a very young Bob Dole who was county attorney in Russell County, who collaborated with 5 or 6 other county attorneys. They challenged the law and had it struck down. So after 1958, obviously, lots of consideration about another severance tax. Interim studies were done. I think the last one prior to this enactment was in 1980. So there was obviously a lot of interest in it, but the current version that we have was enacted in 1983, and just in general, it imposes an 8% excise tax on oil and gas, okay, and coal. Now, coal is not taxed at 8%. It's 1%. And we're looking at tonnage that's removed from coal mines. It's, I think I've got everything set out for you. It's $1 per ton, and we're going to take coal off the table in this discussion because there is a 350,000 ton exemption per mine, and I don't think any severance tax has been paid on coal since the early 90s. So we're really talking about oil and gas today. So we have an 8% tax. What the statute does provide, though, is a credit against that tax, and it's deemed to be a property tax credit for any producing well property that's subject to property tax. So you have an 8% imposition and a credit, as noted in my memo, of 3.67% of the value of the production from a given well or lease. So the effective rate is really 4.33%. What this means in terms of revenue, if you will look over on page, let's see, Exhibit A, and again, you should have a 2-page memo with 6 pages of exhibits. The first exhibit just gives you a pretty good idea of what revenue is generated by the severance tax. For fiscal year 2025, $39,457,000 was the net revenue, and that's after taking into account this property tax credit and all of the exemptions. So when this was enacted back in 1983, we're looking at over $100 million in revenue. So it has declined. Over the years, the exemptions have been enhanced significantly. You might wonder what happens to this revenue after it comes into the state. On Exhibit B, it breaks out exactly where it goes, and you will see that approximately 67% of that goes to the state general fund, and there are other funds where that revenue is transferred by the state treasurer, and some of it goes for education purposes and goes to fund schools both in the counties where the production occurs, and then in just statewide funding for education. So again, Exhibit B lays all of that out. And I thought you might also be interested in knowing on a county-by-county basis where the production occurs. And if you look at Exhibit C, that deals primarily with oil. And you can see that we basically get production out of 90 counties. And some of the counties, the highest one is over 2 million barrels. And you can see that the top 7 counties, the production accounts for 38% of total production. So pretty actually, I was a little surprised that it was 90. It's a little higher than I thought. If you look at Exhibit D, it gives you a map of the state and kind of shows you geographically kind of where the major production occurs. And you can see those 7 counties, Ellis County being the top producer. So that's oil. If you look at Exhibit E, you will see the, I'm sorry, if you look at Exhibit D, well, we'll go to E, and it shows you the gas production on a county basis. And there you can see that just 47 counties actually have gas production, and the top 3 counties with over 10 million MCF is roughly 40% of total production statewide. But again, Exhibit F will give you a pretty good illustration of where the major production occurs, and it's no surprise where it is. Those 3 top producing counties in far southwest Kansas. So I indicated that the figures that were provided were net of exemptions and credits, and laid out in the 2-page memo are the specific exemptions, and I'm not going to go through them all, but suffice it to say that for oil now, the exemption is determined primarily by depth of the well and value per barrel of oil, the average value. And if it's a well that's not over 2,000 feet deep, you have production of 5 barrels or less a day, that well's exempt. And if you have a well that's over 2,000 feet in depth and the barrel price is over $16, that well is exempt. And this, if you look on page 2 of the memo, it kind of breaks out in somewhat of a table there. And that table's not in the statute, but that is, a clarification of how the price per barrel will affect the exemption. I can tell you, I don't know what the future holds in store, but right now the average price per barrel, as last measured, was $69. So you'd have to get down to under 16 to start changing the exemptions on a per barrel basis. So in terms of the cost of these exemptions, that's also laid out on page 2. For oil, all of the exemptions that are in the statute, the total impact is a reduction in receipts of $47 million, and you can see that as the top line on the table on page 2, and that's for oil. That comes from 39 filers, and then for gas, 115 filers, $7 million is the negative impact. And then it also lays out at the bottom of that table the property tax credit. That's obviously has the largest, or one of the largest impacts, $38 million. So that is a very quick overview of the Kansas severance tax. Again, a lot of this data that is included in this attachment are the types of data that we look at as part of CRE when we take into account severance tax receipts for making projections of future revenue coming into the state. So I'd be happy to answer any questions if you have any.
Thank you. Representative Smith and then Representative Long.
Thank you, Madam Chair. And if this question is out of order, I can ask it at a different time too. But a little bit different direction here. We used to have on the books, on the statutes, something called the Oil and Gas Depletion Trust Fund. That's some language that I'm actually looking at, maybe trying to take another stab at. It was in place for a number of years. It was repealed when the state was trying to sweep those funds into the SGF. Really, those funds by statute belong to the local counties to help kind of buffer some of the volatility in oil and gas production. I'm not sure how many folks were here in the building when that was in place and active. Would you mind giving us just a brief? And if you're not prepared for that, that's fine. But
I'm not, but I can tell you that the repeal occurred, I believe, in 2017.
Yes.
On that. Kathleen, do you have any insight? Okay. We can certainly provide information to the committee on that.
I was a county commissioner at the time, and I can't remember if it was tied to severance tax or if it was actual production. As we were going through this, I was trying to dig down into my memory and see if I could figure that out. But I might be visiting with you because I think that's something that could help maybe in the situation that we had a little bit earlier with Pratt County and some situations like that. Might be a solution there. But
Representative Long.
Thank you, Madam Chair. And Representative Smith, I remember that being tied to excise tax, the tax. Thanks for being here, Mark. I'm looking at Exhibit A, and it's given us a 5-year window of mineral tax collections. Do you have anything that tells me the highest year that Kansas has had and what year that might have been? Like if we go back to the 90s or the 2000s?
We can go back to the very beginning of the tax.
But we used to collect a lot more than we are now.
Yes.
Right.
Yeah. Over the last number of years, the exemptions have been enhanced meaningfully, and obviously that's had some impact on receipts.
All right, thank you.
Any other questions? Senator Peck.
Thank you, Madam Chairman. Secretary Burkhart, I'm stuck on the 8% excise tax and then the property tax credit of 3.67%. So am I to read that to say that when they pay the excise tax, then that reduces their property tax liability? Is that the simple way to say it?
No, it doesn't reduce their property tax. There is a specific statute in the mineral tax code that says you will get a 3.67 credit against your excise tax if you are a property taxpayer for the property where the production occurs. So it technically doesn't affect property tax per se, but you know, when this was all going through the process, property tax was part of the issue, and that's why the credit presumably was put into effect.
So it's exactly the opposite of what I was saying. The property tax is paid or a credit against the excise tax?
Yes.
Okay. Thank you. Thank you, Madam Chairman.
Basically, so they wouldn't be considered a double tax?
And as you can imagine, when it's going through the process, you always wonder about the impact on the industry and maybe lessening the impact, and this perhaps was one of those areas of discussion.
Any other questions? Seeing none, thank you.
Thank you.
Committee, that's our last conferee. So we're actually back on schedule. Last thing to finish up, Eddie, would be notes from the meeting, or how do you want to proceed with this?
Oh, this was intended to be a discussion time for the committee, for you all to, if you have any follow-up requests for staff after this, obviously we've got a number of those during the presentations, but also if you have anything else that's come up, and also for you all to discuss what you want to do at future meetings.
Going for it. Okay, great. Well, I'll start with the simple thing first. We are scheduled for October 13th, our next meeting. I'd like to know if that's an issue, if we need to take another sampling of the committee. Is there anybody, I know you have a conflict on the 13th. Is that?
I'm just trying to prioritize, so I may be here.
You may.
This is pretty important to me.
Okay, because we would like to do the machinery and equipment in a little bit more depth. I think, would anybody have problems with that? I think we need to take a closer dive at where we're at statutorily.
Madam Chair, my only problem is the local consult for transportation is in my hometown the next day, so that's
Ooh.
where I get my problems. But I may just be online.
Okay, online would work if it would work for you. Okay, that'd be great. Does anybody else have a conflict?
I have another committee meeting.
The same day?
But I can jump back and forth or.
Why don't we do this? Eddie, we'll poll the committee again, and you guys reply to Eddie, and then we'll take the consensus and see where we can land. We want to make sure as many people as possible. And if it's, it's going to be hard to find a date at this time because of all the other interim committees. Would it be better to go into November for the committee? I mean, this is not pressing information. We could do that, okay. Eddie's going to double check. We'll poll for November then, committee. That might help everyone. Okay, we'll do that. We might do 2 days back to back again. I know that's a little intense, you guys. Would you rather have it 2 days together, or would you rather have Representative Smith?
I guess my only question, is there anything that you would anticipate at that October meeting that we would need a little maybe lag time before that final meeting to decide?
That's somewhat what we were, that's why we had the break in
Right.
between, because we thought topics might come up that we needed a more in-depth research. So we may not do them two together, but we could do 2 in November. So maybe one earlier November, or actually December. We could even go into December if we have to. So we'll look at that. I know, that's Representative Sawyer's favorite time to come to meetings. Understand, believe me. Okay, well, we'll take a look. Eddie will poll instead of trying to decide today. Anything else, committee? Any discussion on any of the topics you heard? Anything you want to deeper dive on? Representative Sawyer.
I think we talked about it, but if we can get more in-depth and better numbers on HPIP, it's just get a handle on how much is being used each year, then how much is out there and potentially could be used.
So we're looking at a possibly December, January meeting if we do that, but maybe that would be worth it. We do need HPIP. I agree with you. Kathleen, would that be asking way too much for a later December meeting? Possibly for HPIP? We'll do what we can. Okay, I know you will. You guys have been going over and above. Much appreciated. And you inherited a situation that I don't envy you. So thank you. Yeah, no, I agree with you. We do need those numbers going in to get a better understanding. And one of the questions that the department, you could get back to Eddie on this, is are there other tax credit programs that we need to be aware of to get our head wrapped around this, that we could be in a similar situation if we're not careful. So you might have a good idea where we're at on Panasonic too, what they've collected, not collected. Maybe that's something we could look at also. But there's nothing we can do legislative. That's a done deal. So, yeah. Any other comments, questions? Deeper dive on nameplate capacity, maybe? Okay, I'm getting some head nods. Okay. I think we'll get some more information on that then. Property valuations, we covered those extensively. I know a couple of people have reached out to me. They'd like to testify on it now. I don't know. Do you guys want to hear more scenarios throughout the state on valuations. We do need to, I mean, we've got a situation, a system that we need to take a look at, and, okay. So we'll do some brainstorming ideas and try to figure out. Okay. Any other? Representative Sawyer-Clayton.
I mean, so I'm just substituting. So theoretically, Representative Stogsdill will be back, but maybe a background on assessed valuations and the history of that. I did ask Eddie about some of that rundown in an email.
Absolutely. Anything else, committee? Now's your chance. Oh, thanks. No, I think we're in good shape. Committee, I thank you for your work, and I'd like to thank staff. I know you guys, we couldn't do it without you. I say it, but I mean it. Committee, we're adjourned.